Hello and welcome to the citywide labor laws for all employers operating and doing business with the City and County of San Francisco. This webinar is hosted by the Office of Labor Standards Enforcement, OLSC, and thank you for joining us. My name is Beverly Popek, and I'm a Supervising Compliance Officer at the Office of Labor Standards Enforcement, and I'm your host for the day. Our office is here to help you understand your labor compliance requirements. So to kick off this very webinar in which we have a whole day planned and packed for you, I'd like to introduce to you Patrick Mulligan, the Director of the Office of Labor Standards Enforcement. Good morning, Pat.
Thank you, Beverly. Good morning and welcome to all attendees of this webinar training of San Francisco labor law. Established in 2001 by the Board of Supervisors and then Mayor Willie Brown, initially for prevailing wage enforcement, the San Francisco Office of Labor Standards now oversees more than 40 different labor laws, many of them the first of their kind in the country, and a few of them still the only ones of their kind in the country. Since its inception, OLSC has collected more than $170 million in worker restitution, testament to the great work of staff who will be making presentations today. Ultimately, our goal is to provide resources to employers and workers to establish a strong atmosphere of labor compliance, elevating workers, and leveling the playing field for responsible employers. I will say there's a considerable amount of information that will be provided today, but I would also welcome everybody to check out OLSC's website. We have more than 30,000 hits a month on average, so it's one of the most frequented websites within the city, especially for a small office, and it's a great resource. And then there'll be plenty of contacts that are provided both through email and hotlines in our office for the various labor laws. Thanks again, Beverly. I appreciate all your work in organizing this presentation, and you can take it over. Thank you.
Thank you, Pat. So welcome to session one, Introduction to Citywide Labor Laws. We have a whole day planned for you, and before we get to the presentation, I'd like to go through some of the features of our WebEx webinar so that you can get the most out of this webinar. First, the slide deck and a recording of this webinar will be available on our website. Just give us a few days. We will post it so you can get that information in about a few days. Also, a schedule with the entire sessions and what time they start and end. It's also on our website. So you can check out to plan the rest of your sessions for today, because I know that folks will come and go as they please. So with that said, we have our chat box. You should open up your chat box to see public announcements or helpful information that complements the presentation. So for example, if you open up your chat box, you're going to see the URL for the website, as I mentioned, where we'll have our slides as well as our recording, and of course the schedule of today's event. You can also chat or message the co-host, which is myself and my colleague Jade San Diego. Just a heads up, Jade and I are doing, so we may not be able to respond if we're presenting or doing some things in the background, but please send us your questions and we will respond just as soon as we can. So how can you ask questions and get answers? Today, we have a questions and answers box feature available for you to use. So if you're not familiar with WebEx, go down to the bottom right and click on those dots. You're going to see a questions and answers box. Just go ahead and open that up, and that's where you will send us your questions through this box as we are presenting, and staff will do their best to publish an answer by the end of the session. Some of the questions may require more information, and you may be asked to contact us. Also, if you don't get an answer during the webinar, our staff will contact you in the next few days at the email address you used to register for this webinar to set up a time to meet or provide a comprehensive answer that's just not available in a quick answer during the session. Now, at the very end of the presentation, at the end of the session, we will have a live question and answer session in which the presenter will select questions to be answered live, and we will do that towards the end of the presentation. I just want to make note of this. Today's this entire webinar is not intended for companies who operate at the San Francisco International Airport, also known as SFO. Citywide labor laws do not apply to the airport because the airport is not located in the city and county of San Francisco. So that's one of the first things you're learning today. So again, welcome to session 1, Introduction to Citywide Labor Laws. I'm your host and presenter, Beverly Popak. My colleague Jade San Diego is in the questions and answers box, and also a co-host who will try to answer any questions you send that way. Sally Chin is in the chat box, sharing some useful and helpful information in terms of URLs. Now, the goal of this session is to help you understand the citywide labor laws as an overview and exactly which citywide labor laws are relevant to you. Pat mentioned that we have a lot of labor laws over here, and it can be very overwhelming. So this session is meant to help you get a bearing, get an understanding, hopefully plan if you haven't done so already. So what citywide was, and you keep hearing me and you'll hear others refer to labor laws this way. Citywide labor laws are labor laws that are required for all businesses who operate and have employees in the city and county of San Francisco. And over on the right-hand side, there's a little picture of the city and county of San Francisco. And please note that the San Francisco International Airport is not located in there. So that is a very basic and simple definition of what you need to understand about citywide labor laws. If your business operates in San Francisco, the city and county of San Francisco, and you have employees, you need to really look at these labor laws to see which ones are applicable to you. So does it matter where your company is headquartered? This is one of the most frequently asked questions that we have in this particular session. And for that fact, for almost every single labor law, we always have companies asking us, our company is not headquartered in San Francisco. Does this really apply to me? And the answer is no, it does not matter where your company is headquartered. What matters is that you are operating in the city and county of San Francisco. And if that's true and you have an employee or employees, you need to take a look at the citywide labor laws and figure out which ones are relevant to you. And how can you do that? You really have to understand what your employee count is. So this is the key to everything today. And we're making it super simple that you must understand what your employee count is. And the employee count is anyone and everyone working for the employer anywhere in the world. So today you're going to hear employee count. This is also a global count because you count all of the employees that work for the company anywhere and everywhere in the world. And you don't pay the people out in San Francisco. You don't count just the employees in San Francisco. Employee count again is all of your employees that works for the company anywhere and everywhere in the world. It's really that simple. And as simple as it is, I know sometimes there are questions, but that's really where you need to start and understand. And if you don't know exactly what your employee count is, it's okay. You can just ballpark it. Is it 5 employees or under? Is it 5 or more? Is it 20 or more? You'll see in the next coming slides that you can probably ballpark it and you can plan your day and figure out the citywide labor laws that are relevant to you. So once you know the size of your company, that employee count, you can basically figure out which citywide labor laws are relevant to you, and you can make a list. And we're going to help you make this list, in which we've created some handouts and things like that. So not to worry, and it's wonderful if you already have a list and you've planned your day. I want to bring your attention that we have for-profit organizations and nonprofit organizations, and we have two different worksheets, one for profit and one for nonprofit. So as you go to these worksheets, they are found on the OLSC webpage for this event. You can download the two worksheets, so please pay particular attention to which one is relevant to you, if you're a nonprofit or you're a for-profit. And then again, if you haven't done so, open up your chat box and the URLs for these worksheets will be found there. You can click on it and you can go directly right now and download these particular worksheets. And I'm going to show you what the worksheets look like. So if you can't download them now, you're going to do that later. Awesome. You can access this information later. And this is what the first worksheet looks like. Again, take a look at the header. This is for-profit companies, and these are the citywide labor laws. And once you know how many employees you have in the world, and you can ballpark, really understand which of our citywide labor laws are relevant to you. So starting on the left-hand side, we have all employers. We have minimum wage, paid sick leave, consideration of salary history, and lactation in the workplace as labor laws that you need to comply with regardless of your size. So remember now, you're an employer if you have at least one employee. So take a look at that. And, our day follows with this logic of the size of your company. Moving on over to the right, if you are an employer with 5 or more employees, you add the Fair Chance Ordinance to your list. And then moving one over to your right again, we have employers with 20 or more employees. And the labor laws that are added there would be the Healthcare Security Ordinance, Family Friendly Workplace Ordinance, and Paid Parental Leave Ordinance. So just a heads up that the Family Friendly Workplace Ordinance has been around for a while, but it just recently went through major uh, amendment a couple years ago, and it's changed quite a bit. It's almost one ordinance with different requirements. So I welcome and encourage you to attend that session. And then moving on over to the far right-hand side, if you are an employer with 100 or more employees, you need to add the Military Pay Protection Act, which is, it's just about a year old or so. And then we also have the Public Health Emergency Leave. So this handout is there for you to download, mark up as you wish, and look at. Now, this was for profit. I'm going to move on over to the nonprofit handouts. So nonprofit entities, this is the handout for you. If you were listening, it's very similar. It looks the same, but there are some differences. So on the left-hand side, all employers for nonprofits, you need to comply with the minimum wage ordinance, paid sick leave ordinance, consideration of salary history and lactation in the workplace. If you have 5 or more employees, you start moving over to the right, you add the Fair Chance Ordinance. And then one more over to the right, if you have 20 more employees, you have to comply with the Family Friendly Workplace Ordinance, as well as the Paid Parental Leave Ordinance. And then if you have 50 or more employees, then you must comply with the Healthcare Security Ordinance. This is the biggest difference between nonprofits and for-profits. The labor laws that are required for the threshold of 20 or more and 50 or more employees. So please note, again, that if you're a nonprofit and a for-profit, you need to look at the right handout. And then moving on over to the far right-hand side, if you have 100 or more employees, you need to understand the Military Pay Protection Act, which again, that is a very new act that was added here, and as well as the Public Health Emergency Leave. So that concludes two sheets that we have for you. Again, please open up the chat box and you will get the direct URL so that you can download the applicable worksheet for you to use back at the office. Now, some tips and best practices for all of this and for today. I want to thank you for attending. Learning the requirements of all of these labor laws, but exactly which labor laws are applicable to you. I hope this session helps. You plan your day and, of course, plan and understand what you need to do to comply with everything that's required here when you do business in the city and county of San Francisco. So attending webinars like today does help. Sometimes after this, you're overwhelmed, but if you attend these webinars, you're going to learn a lot more, and it's also bite-sized pieces. You can watch recordings of this and take it one step at a time. We have a lot of information on our website. Our director, Pat Mulligan, mentioned that our website is highly utilized and it is just packed with so much stuff. Check it out. I mean, it's almost like a cliche that people always say, go to our website, go to our website. But we indeed have a lot of resources for you. Under each ordinance's webpage, we have an overview section. That's at the very top. It gives you a summary of what the requirements are, what the law is about, in other words. Then if there are required posters and forms, we have an option where you can and the posters and forms and all of these posters and forms are available in multiple languages where you can just download and print out. It's in color, but you should just print it out and post it as there are posting requirements. If you are interested in the legal authority, the legislative stuff behind the scenes, we have that available to you and you can read it. And of course, the resources section, we have a wealth of resources on our page as well as other parts. One in particular that I'd like to mention to you is the second to last bullet point, which is the OLSC Video on Demand Library. And now you're thinking, my goodness, I'm attending this webinar today. Why would I need to go to the Video on Demand Library? The Video on Demand Library is not constrained by the time we have today. And the presenters for each ordinance present a lot more examples and details and different examples than you are receiving today. Today is more of a highlight and you will understand the ordinance, but if you want to really dig in and get into the weeds, so to speak, I highly encourage you to go to our OLSC Video on Demand Library. And with those videos, we have the companion slide deck so you can follow along. And then, of course, the last bullet point we have here is our contact information. OLSC prides ourselves on being very responsive within 24 hours to your emails and phone calls. If you do indeed get a voicemail, it's because we are not available and we will call you back. So if you leave your name and your number and maybe a little bit of information while you're calling, that's really going to help us and we will contact you and we will meet with you. So meeting with you, that is really something that we're open to and welcome to. So if you would like to make an appointment because all of this doesn't make any sense, you just need to speak to someone, you don't know where to get started, or hey, you do have specific questions about a specific ordinance such as paid sick leave ordinance, you can contact us at one of our units and we will assist you. So those are some tips and best practices that I hope you'll take with you for this session and the rest of the day. Now, this particular slide is our general contact information for the Office of Labor Standards Enforcement. We are located at San Francisco City Hall in room 430. It's probably best to make an appointment because we have so many units and we want to be most efficient in serving you and helping you. Just give us a heads up, make an appointment if you want to come on in, or we do have virtual capability where we can meet with you online. At this time, are at our live question and answer session. You can still submit a question and answers box that may be selected to be answered live. And then I think I saw that Jade, she was answering some questions along the way. But Jade, do you have questions from the participants for this particular session?
Beverly, yes, thank you. Good morning. Our first question is there a difference between the employer count and global employer count? Is the employer count the employees we have working in San Francisco?
Yes, so this is a commonly asked, frequently asked question. I use the word employer count and global count. It's one and the same. So throughout the presentations today, you will hear our presenters, our compliance officers, pretty much use the same thing. And what it really means is that you as an employer must count all of the employees who work for you anywhere and everywhere in the world. So that makes it super simple. And then I think the second part or the other part of that question, Jade, was the person wanted to know, does it matter how many people are in working in San Francisco?
Correct, yes.
Yeah, so that is a common mistake. So don't you need to know who works in San Francisco because ultimately the labor law will apply to only people who work in San Francisco. But for your count, you just don't count the people working in San Francisco. You count the employees working for you anywhere and everywhere in the world. All right. Are there any follow-up questions to that one, Jade?
This one is like a piggyback to that question. What does operating in San Francisco mean exactly? For example, if our only physical location is in the East Bay, but we deliver product to San Francisco-based customers, do SF labor laws apply?
Yes. So it sounds like this particular employer is located in the East Bay, which for folks not familiar with San Francisco is not in San Francisco, but the company delivers or provides some type of service within the city and county of San Francisco. So in sum, these labor laws do apply to the company and it applies to the employees who work in the city and county of San Francisco. Did was there information? Are they delivering or
No,
providing
that was
service? Okay, so I'll take some liberties here. So if you send your employees to the city and county of San Francisco to work there, meet with customers, provide services, maybe fix things or consult or deliver items, you have to understand that your employees are working in the city and county of San Francisco, and you as a business are operating in the city and San Francisco. So these labor laws today will apply to you, and of course, only for the employees working in the city and county of San Francisco. So yeah, did I answer all those pieces, Jade?
yes.
Great.
Okay, and then next question says, thanks for the presentation and the handouts, but this is overwhelming because there are a lot of labor laws. What can you recommend to me as my next steps in learning about all of these labor laws?
So yeah, I think it can be very overwhelming. I would take a look at our handouts and also our schedule for the day. And if you note on the schedule, now that you've attended this session, you will see that each session is organized by how many employees you have. For all employers, That's super simple. I highly recommend everyone attend those sessions with all of those ordinances under all employers. But if you have less than, 20 employees, maybe you only attend um, certain sessions. If you have 100 or more employees, you probably should attend the whole day. So take a look at your size of the company. How many employees do you have working for you anywhere and everywhere in the world? And even with a ballpark number, you can figure out which labor laws are relevant to you and just plan the rest of your day. And of course, if it's not relevant to you, you don't have to attend. And if you make a mistake, this is all going to be recorded, and we have a wealth of resources on our website that you can always follow up and watch recordings, read slides, and a lot more. And ultimately, if you really need more help, you can contact us and make an appointment, and we can assist you.
Okay, thank you, Beverly. Do we have time for one more? This is
Yeah, we
okay.
have time for one more.
Okay, because this is a pretty repetitive question. For employee count, what happens if you have people doing work for you globally, but they're not employees, or alternatively, they are working for a third-party employer of record?
Okay, so this is a good one. So when we say you need to figure out how many employees are working for you, we're using the IRS definition of employees. So depending on how that falls, that is really the answer to your question. Yeah, well, that's all the time we have for this particular session. We are going to take a short break before we head on over to session 2, minimum wage ordinance and paid sick leave ordinance. That session is going to start at 9:30, so we're going to take a quick break and we'll see you soon. Thank you. Hello and welcome to the Citywide Labor Laws webinar for all employers operating and doing business in the city and county of San Francisco. Thank you for joining us. My name is Beverly Popek, and I'm a supervising compliance officer here at the Office of Labor Standards Enforcement and your host for the day. Our office is here to help you understand your labor compliance requirements. So welcome to session 2. This is our minimum wage and paid sick leave ordinances session. If you're returning from session 1, welcome back. We hope you can join us for the whole day, but come and go as you please to the sessions that interest you. The schedule is published on our website and on the WebEx registration page. Please open up your chat box found on the bottom right-hand side, and the URL with today's schedule will be found there so you can plan the rest of your day. Before we get started, I'd like to go through some of the features that we have in our WebEx webinar to help you get more out of this webinar. First, the slide deck and a recording of this webinar will be available on our website in the next few days. Our chat box. You should open up your chat box to see public announcements and helpful information that complement the presentation. So for example, the URL to the schedule will be found there. You can also chat or message me and also our co-host, Jade San Diego, and we can answer your questions there as well. But if it's a question that should go in the questions and answers box, today we have a questions and answers box feature for you to use. So as you are listening and watching the presentation and a question comes up, just send us your questions through this box during the presentation, and staff will do their best to publish an answer. Some questions may require more information, and you may be asked to contact us. Also, if you don't get an answer during the webinar, our staff will contact you in the next few days at the email address you use to register for this webinar to set up a time to meet or just provide a comprehensive answer that's just not possible during today's session. At the very end of the presentation, at the end of the session, we will have a live question and answer session in which staff will select your questions to be answered live by the presenter. Now, before we get session, I want to be clear that this presentation and this entire webinar event is not intended for companies who operate at the San Francisco International Airport, also known as SFO. Citywide labor laws do not apply to the airport because the airport is not located in the city and county of San Francisco. So here we are. We are at session 2, minimum wage and paid sick leave ordinances. I'm your host, Beverly Popek. Today's presenter, we have Helen Morales Velasquez. In our questions and answers box, we have Josh Pastrich, so please send over a question to Josh. And in our chat box, we have Sally Chin. Good morning, Helen.
Good morning, Beverly. Thank you for joining us. My name is Helen Morales Velasquez. I'm a contract compliance officer with the Office of Labor Standards Enforcement. And today I'm going to be talking about the minimum wage ordinance and the paid sick leave ordinance. The current San Francisco minimum wage ordinance, and as it became effective July 1st, 2024, is $18.67 per hour. And every July 1st of every year, it gets adjusted based on the annual calculation of the Consumer Price Index. Okay, who's covered? So this, the minimum wage ordinance applies to employees who work at least 2 hours per week in San Francisco, and those who qualify as are defined under the California Labor Code Section 1197 as employees, and also applies to participants of the Welfare to Work program. If you have specific questions regarding the minimum wage, we have our hotline. You can send an email message as well, or you can visit our website. You can obtain posters, materials, information on our website as well. Okay, moving on to paid sick leave. So the San Francisco paid sick leave ordinance, it applies to all businesses in San Francisco. If you're conducting business in San Francisco, you are required to provide the paid sick leave. And it applies to employees who perform work in San Francisco 56 or more hours per year. This includes employees working on a temporary basis as well. The minimum compensation ordinance is a contract law, and what it does, it integrates the paid sick leave into the PTO requirements. This is a specific law. So if you would like to obtain more information, you can watch the on-demand videos that we have on our website, the MCO webpage. You can also read the MCO rules and regulations, or you can contact the unit directly at our email address. Okay, so how the use of paid sick leave. So it can be used for, the employees can use it for illnesses, injury, obtaining medical care, treatment, or for a diagnosis. The use of paid sick leave can also be used to provide care for family members, persons that would be a child, a parent, a legal guardian, a ward, a sibling, grandparent, grandchild, spouse, domestic partner, or a designated person. It could also be used for victims of domestic violence, sexual assault, or stalking. So the accrual, how it works is that employees accrue 1 hour of paid sick leave for every 30 hours worked. And the accrual starts on day 1 of employment, and it can be used after 90 days. Employers can cap the accrual. So for small employers, you can cap the accrual at 40 hours. And for larger employers, you can cap the accrual at 72 hours. Now I do have to mention that the California state law has a different higher cap. So we are providing you with the Division of Labor Standards Enforcement contact number and their website so that you can go ahead and obtain more information about the California state law on paid sick leave. Continuing on with the accrual and the use of paid sick leave. So the caps are not annual, and the accrual carry over from 1 year to the next. The employers have an obligation to notify the employees of the paid sick leave accrued each pay period, and the employees can use any paid sick leave accrued. We have a commonly asked question here that we're providing you as an example. Can a company front load 72 hours instead of using an accrual method? So although this is technically legal, we strongly recommend against it because it doesn't relieve the company of any record keeping obligations, and it creates additional monetary obligations to the employer. That being said, a company can front load hours, and the OLSC will consider this an advance on paid sick leave. And what it does, it will just put a temporary halt on accruing any sick leave until the employee has reached the time where they would have accrued the 72 hours. And then at that point, the employee would resume accruing paid sick leave. We have a scenario here. So an employee on January 1st had 72 hours carried over from the previous years, and they call in sick and use all 72 hours. Then the employee comes back to work, and from mid-January to December, they work an additional 1,944 hours, and they accrue 64 hours of paid sick leave. At the end of December, that employee calls in sick and uses the 64 hours that they've accrued from mid-January to mid-December. An example of a compliant payroll systems are where employees accrued 0.0333 hours of paid sick leave for every hour worked. So 1 hour of sick leave earned divided by 30 hours worked. Employers, as mentioned earlier, can establish a cap of 40 hours for small business and 72 hours for large business or large employer. The balance in an employee's accrued unused sick leave will roll over from year to year. If you have paid sick leave questions, any specific questions, here's our contact number, our email, and you can also visit our website to obtain more information about paid sick leave. Thank you.
Well, thanks again, Helen. So folks, this is our live question and answer session time. I just want to remind you that if you have a question, please put your question in the question and answers box. If you've put a question in the chat box, just go ahead and copy the question that you put into the chat box into the questions and answers box, and the staff folks who are of the minimum wage and paid sick leave ordinances will be able to answer your question and it'll get to them. So with that said, we do have some questions, Helen, that came in that Josh selected for you. And I don't think it doesn't look like there's any questions with the minimum wage. It looks like that's super clear. Thank you. So all of the questions it looks like for today is under the paid sick leave ordinance.
Okay.
So the first question is it convenient to front load sick hours?
So as mentioned before in that example that we gave you, it doesn't save you. It's not convenient because it doesn't save you on tracking the hours. You still have to track the hours because you have to, you know, find out at which point the employee will accrue or up to what point the employee would have accrued the hours that you have front loaded so that after that point the employee can resume and continue to accrue sick leave hours.
Thanks for that. And then the second question is, can I ask for a doctor's note?
Okay, this is good. Employers may not require a doctor's note or any type of documentation for the use of paid sick leave of 3 or fewer consecutive work days. So that's your number, 3 or fewer. You may not ask for a doctor's note.
Okay. This one is about calculation. How do you calculate sick hours for salary employees?
So for salary employees, you would use the 40-hour work week and then just do the calculation of the 1 hour for every 30 hours worked. That's good.
Okay. So it sounds simple, but I think people always ask that question.
hmm
So this one's asks, may an employer require its employees to use paid sick leave in 1 hour increments? I guess they're just asking about the increments and what they can do in addition to that too.
Okay. Yes, however, the employer may choose to permit its employees to use paid sick leave in less than 1 hour increments. It's up to the employer if they wish to do that for the employee.
Okay. And then let's see. Here's another question. If an employer rehires a former employee, can that employee use previously accrued paid sick leave?
That's a good question. So if the employee is rehired within 1 year from the date of separation, they get the paid sick leave gets reinstated. So any accrued and unused paid sick leave must be reinstated. So if it's from within 1 year from the date of separation. Now, if the employee is rehired after 1 year from the date of separation, they lose the sick leave bank, but they don't have to wait the 90 days to take the paid sick leave.
Okay, great. Well, I'm getting a message from Josh that these are the questions that we have for a question and answer session for today, and all of the questions that have come in need a little bit more time. And folks, that means that our paid sick leave and minimum wage unit will contact you within the next 2 days at the email address provided. And if you leave a phone number, I'm sure they'll call you as well. But if you still have questions regarding paid sick leave or minimum wage after we end the session, just go ahead and put it into the questions and answers box, and we will forward those questions over to that particular team. I want to thank Helen for her presentation today.
Thank
And
you.
folks, thank you again for sending us questions. We are going to start our next session at 10 o'clock, so we're going to have a break in which we will go through the consideration of salary history and lactation in the workplace ordinances. And we will see you then. Thank you. Hello and welcome to the Citywide Labor Laws webinar for all employers operating and doing business in the City and County of San Francisco. Today's webinar is hosted by the Office of Labor Standards Enforcement, OLSE. Thank you for joining us. My name is Beverly Popek, and I'm a Supervising Compliance Officer at the Office of Labor Standards Enforcement and your host for the day. Our office is here to help you understand your labor compliance requirements. So welcome to session 3, consideration of salary history and lactation in the workplace ordinances. If you're returning from a previous session, welcome back. I hope you can join us for the whole day, but come and go as you please to the sessions that interest you. The schedule is published on our website, and it's also on the WebEx registration page. If you haven't done so already, please open up the chat box on the bottom right, and the URL with today's schedule will be found there. Before we get to the presentation, I'd like to go through some of the features of our WebEx webinar to help you get more out of this event. First, the slide deck and a recording of this webinar will be available on our website in the next few days. Our chat box, as mentioned before, please open up your chat box to see public announcements and helpful information that complement the presentation. You can also chat or message me, your host for the day, or my co-host, Jade San Diego. Now, how can you ask questions and get answers? If you have questions about the presentation, please put your questions in the questions and answers box. Do not send your questions in the chat box. So be clear, just put your questions in that questions and answers box. And once we have those questions in the questions and answers box, staff will do their best to publish an answer. Some questions may require more information, and you may be asked to contact us. Also, if you don't get an answer during the webinar, our staff will contact you in the next few days at the email address you used to register for this webinar to set up a time to meet or to just provide a comprehensive answer that's just not available during the session today. At the very end of the presentation, we will have a live question and answer session in which staff will select your questions to be answered live by the presenter. So bottom line is, if you have questions, do not put it in the chat box, put it in the questions and answers box. I just want to be clear that today's presentation and today's entire webinar is not intended for companies who operate at the San Francisco International Airport, also known as SFO. Citywide labor laws do not apply to the airport because the airport is not located in the city and county of San Francisco. So here we are at session 3, consideration of salary history and lactation in the workplace ordinances. I'm your host and presenter. Jade San Diego is in the questions and answers box, and also my co-host for the day. Sally Chin is in the chat box. So please use the appropriate boxes to ask questions, which will be the questions and answers box. So let's start it off with the consideration of salary history ordinance. The consideration of salary history ordinance has a focus on job applicants. And this ordinance intends to minimize the gap in wages between men and women. The thought is that if a person has a lower wage rate from the beginning of their employment career, then this is likely to continue on a similar path if salary history is taken in consideration for future positions. So this is what the ordinance is trying to prevent. So it's really a simple law. I want to go through some of the key provisions of this particular ordinance. The first one being that employers may not ask applicants about their current or past salary. So as you're hiring folks, you have an application, and then you'll eventually select applicants to correspond with, maybe by text, email, in person, virtually on the phone, etc. You cannot ask them about their current or past salary information or history. So that's the first thing. It's super simple. The second key provision is that you as an employer may not disclose a current or former employee's salary history without that employee's written authorization unless the salary history is publicly available. So if the salary history is publicly available, it's on the web, it's on the internet, that's fine. No worries there. However, if someone calls you up and says, "Hi, Beverly's applying for a job. She put you down as a previous employer. Can you tell us Beverly's salary history? What was the last salary? How much did she make, et cetera, et cetera?" You can't disclose that information unless you get that former employee's permission, and it needs to be in writing. So this is very, very important. So keep that in mind. Now, the third key provision of this ordinance is that an applicant may choose to share salary history information voluntarily and without prompting. So if they do this, then you may consider the salary history in determining what salary to offer that applicant. So let's unpack this a little and give you some examples of how this works. Maybe you're down to the final phase in terms of an interview, and all of a sudden the applicant says, "Well, I really want this position, and I'd like to have X amount of money because, based on what I'm making now," and other things that they voluntarily share without your prompting, they say. Now, if the applicant chooses to share that information voluntarily without your prompting, then of course you can use the information in your final offer. So that's basically it. It's a super simple law. The best practice here is to ensure that all steps of your hiring process does not inquire about salary history. The most area of issue, what we see here is that sometimes employers are using job applications where there is a field, an item where it says, what was your starting pay and then your ending pay, or your starting hourly rate and your ending hourly rate. You can't have that on there. So that's something to consider. And most importantly, which is the second bullet point, is that you might be a one-person shop doing all of this HR stuff from start to finish, but if there are others, you need to inform, educate everyone involved in the hiring process about the requirements under this ordinance. And this is when maybe you're spearheading the hiring process and everything seems, yeah, that's okay. But if you have an interview with a hiring manager, someone who will eventually oversee and make the decision, you need to have them understand that this information cannot be asked unless it's voluntarily given and you can consider it. This is the contact information page for the consideration of salary history unit. Please feel free to go to our website for more information. This is our direct contact number and of course our email address. So moving right along, we have lactation accommodation in the workplace, and this particular part of the presentation is packed with a lot of information. So first of all, who are the covered employers and employees and covered employees? Covered employees are all employers except for government entities that have employees working in San Francisco. Now, note there's a underline and an asterisk. We're going to get to that in a minute. So that's the definition of covered employer. A covered employee would be all employees working within the geographic boundaries of San Francisco. Note the underline and asterisk, we'll get to that later, including part-time employees. They're covered. So let's talk about why San Francisco and geographic boundaries of San Francisco is underlined and there's a little star. Federal enclaves are located within the city and county of San Francisco, but it is not part of the city and county of San Francisco and not within the geographic boundaries of San Francisco. So if you're local, these examples will make sense. If you're not local, you're going to have to talk to the local folks, or you can call our office to get more information. Federal enclaves that exist in San Francisco, the most commonly seen popular ones where we have employers would be at the Presidio, or Fort Mason. The Presidio and Fort Mason are federal enclaves, meaning this particular law is something that you do not have to comply with. And of course, as mentioned prior, if you are operating at the San Francisco International Airport, this is not applicable at the San Francisco International Airport because the airport is not located in San Francisco. A little bit about the history here. The purpose of this ordinance is to provide a supportive work environment that enables employees who are nursing mothers to breastfeed or express breast milk during work hours. This particular ordinance complements state and federal law, and we as a city and county amended the San Francisco Police and San Francisco building codes to support folks that want to express breast milk during working hours or would like to breastfeed. So let's talk about requirements. Your requirement as an employer is all about lactation breaks. You must provide a reasonable amount of break time for employees to express breast milk. More about these break times, if it's possible, the lactation break time, if possible, can run concurrently with any break time you already provide to the employee. Now, any break time that does not run concurrently with the rest time authorized under the state may be unpaid. So a little bit more about this. If you're not familiar with lactation, you don't understand, lactation is not something you can push a button and a woman can lactate and push a button and it just stops. So in terms of theoretically having break times run concurrently, that sounds wonderful, but you really need to discuss this with your employee. And quite frankly, a lot of times employees are overwhelmed, and this is all new to them. And they and you and them, and they will have to really discuss how to figure out when these break times will be. Now, once you provide those break times, location. Where should this be located? What's acceptable? What's not? The location for lactation is other than a bathroom. It cannot be a bathroom. And it must be in close proximity to the employee's work area that meets the following criteria. So the first bullet point is that it needs to be shielded from view and free from intrusion. So a locked door is an example. It needs to be safe and clean, contains a surface. The surface is necessary in which maybe the person needs to pump, contains a place to sit, has access to electricity, and again, is not a bathroom. More about the location. We have a lot of historic, very nice buildings in San Francisco, but within these historic buildings, there's not a lot of space. So employers in multi-tenant buildings may use shared locations if they cannot satisfy the location requirements on their own. So if there's a lactation room in the building and it meets the requirements that we just discussed, it's probably fine. Now, something else that you must understand about the lactation location and this room is that you must provide in close proximity to the employee's work area access to a refrigerator and a sink with running water. Now, please note that this does not have to be the fridge and the sink with running water does not have to be in the lactation room. So that's something to remember. And I keep using the word a definition, the word close proximity, this phrase. So what is the definition? This definition, it really depends on the specifics of the situation. It has to be close enough that the location does not deter a reasonable employee from using it. So let me unpack that a little bit more about close proximity. Let's say, for example, you are in a historic building in San Francisco or just a building where, hey, you just don't have a lot of room. However, maybe there's a space, a lactation break room that you can have your employee use that's in the adjacent building. The question is, doesn't meet the close proximity requirement here. So you have to figure out, well, how long does it take your employee to leave their workspace, go to the next building to do the lactation break? Is it going to take 10 minutes to get to the room one way? Then it's a 20-minute round trip because there's elevators, there's stairs, you have to go in and out of security. I really don't know. So it all depends on the specific of the situation. We want to be as creative, adaptable as possible. And if you have any questions of whether or not it's reasonable and it meets the definition of close proximity, don't hesitate to contact the Office of Labor Standards and we can help you with that. Another part of the requirement, moving on here, is lactation accommodation policy. You need to have a lactation accommodation policy in which, number one, you identify the process by which an employee may submit a request. So we always say here at the Office of Labor Standards, verbal requests are wonderful as a starting point, but things in writing, you must have it in writing. So please identify the process, create the process if you don't have one in which an employee can submit a lactation accommodation request and needs to be in writing. Number two, you must respond within 5 days of receiving an employee's request. And once that is received, you must engage in an interactive process with the employee to determine the first part, A, lactation break or break periods or periods with an S, and of course the location. So an interactive process is something such as a telephone call, maybe it's an in-person meeting, maybe it's virtual. A lot of times, if someone is making a lactation accommodation request, they are about to return back to work and they're probably still at home. So please engage promptly and to figure out those lactation break period or periods and of course the location. Now, if you need to deny the request, this information is for you. You must provide the employee with a written response that identifies the basis upon which you have denied the request. So in other words, you need to put it in writing and you have to be very, very specific. Now, the following next two slides will give you more information about the possible denials and exemptions. So an employer may establish an exemption from the requirement in the ordinance to provide lactation break or breaks or a lactation space. And such exemptions may not be available under state law. So remember now, this webinar is with the City and County of San Francisco. We are at the city and county level. The next level is a state law level. So although you may be exempt from this lactation accommodation ordinance at the city level, you may still have some state requirements. So please look into that. And then of course at the very bottom here on this slide, you still must comply with the other requirements such as state and federal requirements. So there's state and there's also federal requirements. Now, this last slide about exemptions, undue hardship exemption is really the reason that you can possibly deny the request. And what that means is that if you have an undue hardship, you have a significant expense or operational difficulty when considered in relation to your size, financial resources, nature, or structure of your business. So here are some really good examples for you to understand this of undue hardship in which maybe you have to deny someone's request, such as if you have to build a room. There's just no room left and you have to build a room. And of course, undertaking a construction project, that would be an undue hardship. If you're a restaurant, if you have to remove seating from a restaurant, or if you're in a retail store where you have to remove retail floor space. So that gives you an example of undue hardships. Let's talk about some best practices. The first bullet point in terms of best practice is to really learn about lactation. understand how it works, and really, I think the quickest definition is that a woman cannot push a button and lactate and push a button to stop lactating. So you need to understand a little bit more about that, so that as you are interacting, having that interactive engagement with your employee, you can best brainstorm some possibilities with the breaks and the locations. The second bullet point is that we do have an on-demand lactation video. We get into more examples. So if you want more of this, feel free to go to our on-demand video library and look for the lactation accommodation video. We also have the companion slides to go with it for the on-demand video. Third is that you can use our sample policy. We have a sample policy on our website, but please use it and make it your own. Now, there are some requirements that we went through today in which what you need to have in your policy, so don't eliminate those. You want to have a compliant policy. And then fourth, read the rules and regulations on our website. That sounds very dry and cut, but you should read over it if you're not familiar with this ordinance, and if you're not sure if you're compliant, should look over it. And then lastly, we have a frequently asked questions document on our website. It's in plain language about this ordinance and things that we always get asked. And start there if you don't want to read the rules and regs, and then you could follow up with the rules and regulations to understand more. Best practices, slide number 2. You need to have that policy. It's a requirement. So once you have it, distribute the policy at the time of hire. And if you don't have a policy now, you've been operating, that's fine. Create the policy as soon as possible, make sure it's compliant, and then issue a memo with a copy of the policy to all current employees as soon as possible. And then the next time you revise or publish your handbook, make sure this policy is in your handbooks. The third bullet point is about retaining records. You need to retain records regarding any lactation accommodation requests, your policy, I don't know if you have a request form, maybe you have a request form, all of that stuff, at least 3 years. And if you have any questions regarding any of this, feel free to contact the Office of Labor Standards Enforcement. We can definitely help you and tell you and share with you what other employers have done. So this is our contact information for the Lactation in the Workplace webpage. Feel free to go there to get all of the resources and to contact us. And with that said, this brings us to the end of the session. Please submit your questions for both consideration of salary history and lactation accommodation in the workplace in the questions and answers box. If you did submit a question in the chat box, please go back in there, copy and paste that question, put it into the questions and answers box. We'll be able to track it and get you an answer either live here or in the next few days. So hi, Jade. I know that you've been answering some questions, but I guess what questions do we have in terms of salary history and lactation accommodation?
Thank you, Beverly. Yeah, we have a couple for salary history. The first one is, what if the applicant is negotiating a salary and they give me information about how much they are making at their current job? Can I ask more about this?
So if the applicant has voluntarily given you this information about their salary history, without your prompting, then yes, you can use the information in making your offer or part of the negotiation process.
Okay, a follow-up to that. Are we expected to keep a record that the applicant voluntarily shared this information?
You know, it's not a requirement, but I always think it's in good practice that if this does happen, you should note it and you should put it on the record when it happens. So the date, time, maybe it was at an interview virtually or in person, and what the person said, and basically that you didn't prompt them. Keep it on record on file. You can email it to yourself. If that's more easy, because then you have a date and time stamp memorializing what's happened. Because if there is a question and the Office of Labor Standards for Enforcement needs to contact you to ask, well, gee, someone made a complaint, Beverly made a complaint. This is what Beverly said. You have information to show the contrary to provide to us. So that should be noted.
Okay, thank you. And then last one, can a company acquiring another company ask for incoming employee salaries and use that information to set the employee salaries?
Yes. So if your company is merging or acquiring another company, then you can ask for salary history as part of that process. So that is allowed.
Okay, great. Some questions for lactation. We don't have any parents or anyone who might become parents. Do we need to have a lactation policy?
Yes, it is a requirement that if you're operating here in San Francisco, you need to have this policy. So take a look at our website. We have a sample policy. Make it your own. Please remember that within the sample policy, there are required items that are there, so don't delete that. For example, you have to respond within 5 days to the request. So you do need to have a policy.
Okay, and then we're limited to space. We're limited on space, but we have a very large and nice bathroom. Can we add a chair or couch and use the bathroom as a lactation room?
So the answer is no. A bathroom can never be used as a lactation space, but it sounds very nice in terms of you can add a couch or a chair if you like, but it just simply cannot be used as a lactation space to meet the requirements of this ordinance.
And then the follow-up to that, the sink, can the sink that's required be in the bathroom?
Yeah, the sink can be required, not required, excuse me, it can be in the bathroom. It just needs to be in close proximity to the employee's workspace.
Okay, great. And then the next one, we are located in a very historic building and short on space for a dedicated lactation room, but we think we can arrange to use the adjacent building's facilities. Would that be okay?
So it's kind of similar to the example I went through in the presentation. This is a common thing in San Francisco where folks are able to use a lactation room or have space in an adjacent room. It really just depends how long it takes an employee to get to that other space, and then you have to double it because it's a round trip. So maybe, I don't know. We're going to need some more information. So if you did ask that question, I welcome you. I encourage you to contact us so we can answer that question. And then we only have time for one more, Jade. I'm sorry.
Okay. And then can the lactation space be used for other purposes?
Yes. So you can have, I don't want to say it's a multi-purpose room, but perhaps there's a meeting room in which can be a lactation room. You can have a room in which is multi-purpose to meet the requirements, but the priority is if someone needs to use the room for lactation, that needs to be coordinated. Perhaps there's a sign, there's a policy in which, hey, if the room is being occupied, you just can't go in there. You just can't bump someone because you have a meeting and you want the meeting room. So yes, you can definitely have a multi-purpose room. So
Okay,
folks,
thank you.
thank you so much, Jade. That's all the time we have. We're going to take a short break, and the next session is the Fair Chance Ordinance, and we're going to start in about a minute. Thank you. Well, hello and welcome to the Citywide Laws Labor Webinar for all employers operating and doing business in the City and County of San Francisco. Today's event is hosted by the Office of Labor Standards Enforcement, OLSE. Thank you for joining us. My name is Beverly Popek, and I'm a Supervising Compliance Officer at the Office of Labor Standards Enforcement and your host for the day. Our office is here to help you understand your labor compliance requirements. So welcome to Session 4, Fair Chance Ordinance. If you are returning from a previous session, welcome back. We hope you can join us for the whole day, but come and go as you please to the sessions that interest you. The schedule is published on our website and on the WebEx registration page. Please open up the chat box at the bottom right-hand side, and the URL with today's schedule will be found there. Before we get to the presentation, I'd like to go through some of the features of our WebEx webinar to help you get more out of this event. First, the slide deck and a recording of this webinar will be available on our website in the next few days. And our chat box. You should open up your chat box to see public announcements and helpful information that complements the presentation. So for example, the URL for today's schedule will be there. And then you can also chat or message me or my co-host, which is Jade San Diego. So how can you ask questions and get answers? Today we have a questions and answers box feature available for your use. This is really different from the chat box. So the chat boxes should not be used for any questions you have during the presentation. So as you have questions during the presentation, just put those questions into the questions and answers box, and we will do our best to publish an answer by the end of the session. Some questions may require more information, and you may be asked to contact us. And also, if you don't get an answer during the webinar, our staff will contact you in the next few days at the email address you use to register for this webinar, to either set up a time to meet or provide a more comprehensive answer that's just not possible during the session. At the very end of the presentation, staff will select your questions to be answered live by the presenters. So stay tuned until the end. Now, I just want to be clear that this presentation, as well as the entire day today, the webinar, is not intended for companies who operate at the San Francisco International Airport, also known as SFO, as citywide labor laws are not applicable at the airport because the airport, the San Francisco International Airport, is not located in the city and county of San Francisco. So here we are at the Fair Chance Ordinance session. I'm your host and presenter for this session. My co-host, Jade San Diego, is also working the question and answers box, so feel free to put those questions in there and not the chat box. And for the chat box, open that up. You'll see some public announcements, and we have Sally Chin working in that particular feature. So let's get started about the Fair Chance Ordinance. Who's covered under this law? So for employers, you are covered if you have 5 or more employees working for you anywhere in the world, and you have employees or planned positions in San Francisco. So that's a definition of a covered employer. Moving on over to who are the employees who are covered under the Fair Chance Ordinance. It's someone who works or will work at least 8 hours a week in San Francisco. So that's almost everyone. So that's basically who's covered under the Fair Chance Ordinance. So what is the Fair Chance Ordinance? The Fair Chance Ordinance is a citywide labor law that is required by the City and County of San Francisco. It's a process law. This means that there is a step-by-step process that you as an employer are required to strictly follow when it comes to applicants or employees with arrest and conviction records, if you want to ask about that. I want to note at the very bottom here, the third bullet point, that the state of California has a Fair Chance Act. It is similar but different. The Fair Chance Ordinance here in San Francisco requires a little bit more time for you to give the employee to respond, the prospective employee. I'm going to point that out in the process, but please note that, yeah, the state of California has a similar requirement, but it is different. This is an overview of a compliant hiring process. Now, this slide is very small probably for you, and it's not meant for you to read this right now. I highly recommend that you visit our website and access our Fair Chance Ordinance Employer Toolkit, in which you will be able to see how to comply with the Fair Chance Ordinance every step of the way. We have this toolkit in which will go through all of the pieces and what is required for the Fair Chance Ordinance. And our third bullet point here is that we have our FCO Employer Toolkit broken out into videos that explains every step of the process, from job announcements and applications to initiating a background check after an initial offer. That is, of course, if you want to do a background check. And then after the background check report, what happens? Your initial assessment, reassessment, and then finally any sort of final determination if you want to revoke the job offer. So again, this is a highly processed law with lots of details. I'm going to refer you back to our website to really understand and download all the intricacies of the compliant hiring process. So let's go step by step into the beginning of the process in which you may have a job announcement. Under the ordinance, you are required to have language that must have an affirmative statement of compliance. So this very bottom here, pursuant to the San Francisco Fair Chance Ordinance, we will consider for employment qualified applicants with arrest and conviction records. You can copy and paste this, make sure that it's on the posting. Sometimes we see on these online places that it gets cut out, so maybe put it at the top. Make sure it's viewable for all of the applicants. And remember that your announcements cannot say that someone with arrests or convictions will not be considered, or that a background check must be passed. So your job announcements can't have that. Okay, so moving on over to job applications and interviews. More about the job applications. You cannot ask the applicant about any history of arrests or convictions. And you have to keep in mind that you cannot ask about or inquire into the convictions or unresolved arrests until after a conditional offer of employment is made. So in other words, during the job application interview phase, you can't ask about all that stuff. However, once you make a conditional offer of employment, then you can ask a little bit more and find out more. So right here, right then, you do not have to do a background check if you're not interested and you just want to hire the person. I just want to remind you that. But this is where you can make a conditional job offer, which is number 3. And you just have a choice if you want to conduct a background check or not. There is no requirement under the ordinance to do one. So if you want to just hire them, you can. Now, the rest of this presentation is all about if you want to continue on with a background check. So let's move on over to number 4. So number 4 is that you have chosen to do a background check. Remember that this law does not require you to conduct a background check, but if you want to do a background check, you have to follow the process and requirements in this Fair Chance Ordinance. And you, of course, have the right to do this. So here are 7 categories of information that may not be considered at any time. And this information is on the Fair Chance Ordinance webpage listed clearly. So don't worry if you can't read this, or if you're not getting a copy right now. You will be able to get this information on our website, as well as our companion slides that will be published in the next few days, and it's on all of our recordings and information. So number 1, you cannot consider at any time an arrest not leading to a conviction except unresolved arrests. Can't consider participation in a diversion or deferral of judgment program. You cannot consider a conviction that has been dismissed or expunged. And you can't consider a conviction in the juvenile justice system. And number 5, this one is bolded and underlined because this is the most common mistake. And unfortunately, a mistake in our world is a violation. You cannot consider conviction that is more than 7 years old. Number 6, an offense other than a felony or misdemeanor, for example, a traffic ticket. And number 7, any decriminalized offenses such as cannabis convictions. So you can't consider any of this stuff if you see it on the background check. So now you're sitting there thinking, why is she saying this? Shouldn't the background check company hide this information, mask this information? What you should understand is that when you hire a background check company, the company will provide any and all information going back to the applicant, whatever is found since they are a baby. So you as the employer must put the blinders on and understand that if you see any of this information on the background check report, you just cannot consider it. If you think that's going to be an issue, you can't do it, you should really talk to the company and tell them, hi, I need to comply with the San Francisco Fair Chance Ordinance. I cannot consider any of these 7 categories at any time. Can you make sure when you send me the background check report that this information is not in there? Because sometimes folks, when they see things in the past, although it's maybe beyond back 7 years, they just can't take it back and move forward. So that's some information. Now, there are some exceptions to the prohibited information that I just went through. You can consider convictions and arrests prior to the 7-year look-back period if the job is involving minors, dependent adults, or persons 65 years or older. And you can also consider infractions such as a driving record where driving is a significant part of the job. Now, there are state and federal preemptions. It's a fancy word for saying that maybe there's a federal and state requirement that requires your industry, that job, to perform a background check. If that is the case, then yeah, you definitely can do it. You're not violating or breaking and the San Francisco Fair Chance Ordinance because the federal or state law requires you to do so. Some of the most common examples of state and federal pre-exemptions for the Fair Chance Ordinance would be in the financial services or insurance services industry. So once you conduct a background check, we're going to move on to number 5. You need to conduct an individualized assessment and to figure out, well, is there anything there? And if there is something there, what do you want to do? You want to hire the person, or if you plan to revoke the job offer due to what you see, this is what you have to consider. So the criminal conduct that you're seeing on the background check, how is it directly related to the person's ability to do the job? So for example, if there's something that you see on the criminal background report and for whatever reason you're concerned, but this person is being hired to work alone, cleaning vats, food vats in the middle of the night and there's no one there, is that directly related in terms of the criminal conduct that you saw? Then you must factor in how long ago the criminal conduct occurred. And then is there any evidence of the applicant's rehabilitation or other mitigating factors? Perhaps they went to anger management counseling, they're under treatment, they have certificates. Maybe they are working in a similar job without issue and they're currently employed, but now they're looking to see greener pastures and perhaps come to your organization. And maybe they've demonstrated that this is not a problem. Now, you must provide the preliminary decision to revoke the job offer if you want to do so. There's no automatic rejections. And based on these particular items that I just went through, you're going to have to provide this in writing and explain all of this and what you saw and how it's directly related to your assessment and how this person has ability to do the job. So let's talk about this. Maybe there's something and you feel that you're on the track for rescinding the job offer. You have to provide the applicant a copy of the background report and a copy of that individualized assessment that we just went through. And you must offer the applicant 7 days to provide clarification of errors, background information, mitigating circumstances, and evidence of rehabilitation. So 7 days is bolded and it's highlighted in yellow. The reason this slide has that is because the California Fair Chance Act, that statewide requirement, only requires 5 days. This is where there's a big difference, where the San Francisco Fair Chance Ordinance requires more time. I will caution you and tell you that if you are using a consultant or a background check company to rescind the job offer and handle all of this, because there's a lot of details, like we get it, you must make sure that company, that person that's doing this understands there's a difference, a big difference between the state requirement and the San Francisco Fair Chance requirement. This is where we see the most amount of issues, or what we call violations, to the Fair Chance Ordinance. And this is very simple to remedy. Just make sure you give the applicant at least 7 days. You can even give them more, but at bare minimum 7 days. So once you give them that time, the 7 days, at least the 7 days, and they have the opportunity to provide more information. If they provide information with the background report and new information, you must conduct another individualized reassessment and make your determination. Do you want to hire? Go ahead and hire. But if you don't want to hire, you need to provide the decision in writing and provide a copy of the reassessment and the Fair Chance Ordinance San Francisco poster in that package, as the applicant has the right to file a claim with our office. So these are some things that the Fair Chance Ordinance does not do. The Fair Chance Ordinance doesn't require you to give preferential treatment to hire an unqualified individual with an unresolved arrest or conviction record. That's not what this is all about. And it does not limit your ability to choose the most qualified and appropriate candidates from among the candidates and applicant pool. And it does not require you to conduct a background check. You can do it if you want, but you don't have to do it. And that is really also the fourth point, is that you can conduct a background check. It doesn't stop you from doing that. I'm going to finish up with some common violations to this particular ordinance. One of the most common things that we see that I think you can really change right away is that if you're asking about convictions on the job application, you need to take that off, because that's not allowed. It's not okay. It's a violation. Or number two, if you refuse to hire based on a conviction that is over 7 years old. The third one is that you imply that no individuals with convictions will be hired, saying somewhere that a background check must be passed. Number four, an employer has an improper process of notifying applicants of conviction or unresolved arrest and length of durations. So in other words, if you're doing an assessment and you communicate with the potential applicant, if you are not providing that necessary mandatory information as we went through under the Fair Chance Ordinance, it's a violation. And definitely, I think you understand that you need to give that person at least 7 days to provide any new information for you to consider in the final assessment. Number five, this is something that we see, failing to provide a copy of the background check. If the applicant doesn't even have that report, it's very difficult for the applicant to provide any information or response. So please make sure that the applicant has a copy of the background report. Sometimes that is a direct access or portal through the background check company, and that in itself can be something that you need to help with if the applicant is having issues logging in and getting access to the background check report. And then finally, number 6, I think I've mentioned this before, but you got to make sure you allow at least 7 days for an applicant to review and respond to your questions regarding the background report. So some best practices. I think you understand that this is very nuanced. There's a lot of details. The FCO is a process law. So what you need to do is you need to gain an understanding of the necessary steps of your hiring process, and you have to make sure that whatever you have in place is in compliance with the Fair Chance Ordinance. We have all this on our website. We have our frequently asked questions to the ordinance, and we have a toolkit, an FCO toolkit with all of the pieces and sample forms and questions for you to use during your hiring process. And then certainly contact us to schedule a meeting to discuss the Fair Chance Ordinance as you might have questions. And with this is our last slide in terms of contact information and where you can find the Fair Chance Ordinance webpage and all of the resources I mentioned. So at this time, we are at our questions and answers session. If you haven't done so already, please put your questions in the questions and answers box. If you put a question in the chat box, please copy and paste the question and just put it into that questions and answers box. This is just how the system works and how we're going to be able to track and get back to you if you have any questions we don't answer live here. Hi, Jade. I know that we have some questions. I got your note. What questions do we have today?
Hi, Beverly. Yes, thank you. So the first question, the FCO is very complicated. Are there any resources or information to help our company understand what is required?
It is very complicated. The process can be very lengthy if you want to do a background check. I think the best thing and my advice to you is to download the FCO Employer Toolkit with all of the corresponding pieces to see what you'd like to implement and use, and perhaps you have these pieces to check if it's compliant, and just watch the videos to understand each part of the process. Also, that very slide with all the arrows to see if what the process is, a big overview, is very, very helpful to really break down and help you understand all of the different pieces and processes of the Fair Chance Ordinance.
Thank you. Next question. We use a consultant to do all of our hiring. What if the consultant does something wrong? Is our company liable for any mistakes the consultant does in the hiring process?
So the answer is yes. If you use a consultant or a subcontractor, another company to do all this stuff, and they make a mistake, you are responsible and liable for the mistakes, the violations. So we would contact you and you would be responsible. So the best thing to do is to ensure that the consultant, the subcontractor understands that you must comply with the San Francisco Fair Chance Ordinance because you're hiring people, positions in San Francisco. It is within the state of California, and I think that's a big selling point for a lot of these consultants and background check companies. They know everything. They're going to give you all the information. Well, maybe you don't need to have all that information here, right? As you could see, you have to have someone and a company that understands that there are differences between the state process and the San Francisco Fair Chance Ordinance, and to make sure that you only get the information you really should see, because the information is out there. You can see background information all the way going back to when somebody's like a little baby. That's the phrase applicants use, by the way.
Okay. Next question. What should the employer do when the conviction is pending? Can we proceed with the pre-adverse action based on the pending conviction and ask them to reapply once it's resolved?
No, so you need to put a hold on that, and you need to just move forward in the process. So that's something that you should do.
Okay, thank you. Um, Next question, does the FCO require employers to conduct a background check?
No, so the FCO does not require any employers to run a background check. And I just want to add that it doesn't prevent you from running a background check. But if you want to run a background check, you need to follow the compliant process and also understand the areas in which you should not look into and should not consider as part of the hiring process.
Okay, thank you. This one's a good one. What happens if an employer violates the FCO process?
Um, so I guess I guess it depends if you as an employer maybe you feel that you violated the FCO process, you should contact us right away and we can help you get into compliance as soon as possible and determine any corrective actions that can be made at the time. Um, if there is a complaint that our office receives, and then we contact you to say that, hi, you violated the FCO. It looks like potentially you did. We would contact you and we would ask for information about your process. There's, as you understand, it's a process law, and there's many parts. And if there's something in particular that the complainant brings forward that said, look, this person said in their text and email and the job application that a background check must be passed, and this is what they said, this is what they emailed me, or perhaps you didn't give the applicant at least 7 days to provide information. All of these things are in writing that will be provided to us, and we will present you with any information and all information we have for you to clarify and to show us if there's other information for us to consider. So I think that's two sides of the coin. What haven't I thought about, Jade, with that particular question? That's a very open-ended question for interpretation.
Yes, yes, thank you. Okay, I think we have time for one more.
Yeah, we have time for one more.
Okay, an exemption is supervising minors, but what if they're working in a place where minors are at, but not supervising?
So then that exemption does not apply,
Okay,
right?
thank
Um,
you.
all right. Well, yeah. So the healthcare security ordinance session, which is session 5, will start in about 2 minutes at 11 a.m. So folks, please join us for that session, and we're going to take a short break. Thanks again. Hello and welcome to the Citywide Labor Laws webinar for all employers operating and doing business in the city and county of San Francisco. This webinar is hosted by the Office of Labor Standards Enforcement, OLSC, and thank you for joining us. My name is Beverly Popek, and I'm a Supervising Compliance Officer at the Office of Labor Standards Enforcement and your host for the day. Our office is here to help you understand your labor compliance requirements. So welcome to Session 5, the Healthcare Security Ordinance, also known as HCSO. If you're returning from a previous session, welcome back. We hope you can join us for the whole day, but come and go as you please to the sessions that interest you. The schedule is published on our website and on the WebEx registration page. Please open up the chat box, and the URL with today's schedule will be found there. Before we get to the presentation, I'd like to go through some of the features of our WebEx webinar to help you get more out of this event. First, the slide deck and a recording of this webinar will be available on our website and our chat box. You should open up that chat box on the bottom right-hand side to see public announcements and helpful information that complement the presentation, such as the URL to today's schedule. You can also chat with me, your host, or our co-host, Jade San Diego. But please note that we have a questions and answers box available for you to use. So during the presentation, please send us your questions in the questions and answers box, not the chat box, and staff will do their best to publish an answer. Some questions may require more information, and you may be asked to contact us. Also, if you don't get an answer during the webinar, our staff will contact you in the next few days at the email address you use to register for this webinar, to set up a time or to provide a comprehensive answer that's just not possible during the session. At the very end of the presentation, we will have a live question and answer session in which staff will select your questions to be answered live by the presenter. I want to remind you that today's presentation, and especially this presentation, the Healthcare Security Ordinance, is not intended for companies who operate at the San Francisco International Airport, also known as SFO, as citywide labor laws do not apply at the airport because the airport is not located in the city and county of San Francisco. So here we are. We have our Session 5 here, the Healthcare Security Ordinance, also known as HCSO. I'm your host, Beverly Popek. We have our co-host, Jade San Diego, with me today, and our presenter for HCSO is Gabrielle Moses. In the questions and answers box, we have Maura Prendeville, and working our chat box, we have Sally Chen. Good morning, Gabrielle.
Good morning, Beverly. Thank you so much. Good morning, everyone. My name is Gabrielle Moses, and I am a compliance officer at the Office of Labor Standard Enforcement. And today I am going to be talking you through the Healthcare Security Ordinance, also known as HCSO. So welcome, everyone. I want to share first a little background about the Healthcare Security Ordinance. It's been around for 16 years now. It was implemented January 1st, 2008. And I suggest the easiest way to think about this law is it is a spending requirement. It is not an insurance requirement. What the law does, it mandates that employers spend a certain amount of money on health care for its San Francisco employees. Now, there are different ways to comply with the law, which I will discuss today. But the first step is determining if the business is a covered employer. So who is a covered employer? Well, HCSO looks at the total workforce size, not just the people working in San Francisco. So the minimum threshold, again, is based upon the total number of workers that are performing work in all locations worldwide. And for a for-profit employer, it's a business that has 20 or more workers working for the company during a quarter. Now, the threshold is a little higher for nonprofits that it's 50 or more persons performing work for them in a quarter. So, for example, if you are an employer with, let's say, 2,000 employees working in Denver, and you have one person performing work in San Francisco, then you would be a covered employer because HCSO looks at the 2,000 employees, not just the one worker in San Francisco. So again, employers must consider the number of workers in all locations throughout the world. And HCSO, though, does not cover, government employees. So if you're on this call today and you work for a government agency of any sort, federal, state, or local, then you are not covered by HCSO. So assuming that you are a covered employer, you need to decide which of your employees are covered by this law. So who is a covered employee? Well, the definition of a covered employee under HCSO is very broad. One is that the person should be employed for at least 90 calendar days for the company. And two, the person should work at least 8 hours per week in San Francisco during a quarter. So you should expect the most of your San Francisco workforce to be covered by this law, meaning they are entitled to healthcare spending. Now, as employers, you should look at where the work is performed. If the employee is working at home and their home is in the geographical boundaries of San Francisco, then they are covered under this law. I would point out, as it says on this slide, that there are some employers like the San Francisco Airport, which has San Francisco in its name, but it's not within the geographical boundaries of San Francisco. So as Beverly talked about earlier, these employers are covered by another law and not the HCSO. But the basic rule of thumb is to assume that your San Francisco workers are entitled to healthcare spending. There are a few exemptions, however, and those exemptions are very rare, but I will discuss those a little later. So let's move on, assuming that your workers are covered employees. Then what are the requirements? There are 4 requirements that I'm going to talk about today. The first obligation for employers, and this is the most essential requirement of the law, is that employers must satisfy the spending requirement. So at the end of each quarter, employers must ensure that they spend a particular rate of spending, a particular spending rate. And these expenditures are based upon the employer size globally, not just the San Francisco workers. So if you're an employer and you're looking at your trying to determine your size and your spending requirements, let's just say that you're a company again with 2,000 employees across the globe, and one of them are in San Francisco. So you would use the rate for an employer who employs more than 100 people. So the expenditure rates, I do have them listed here for 24 and 25. They do change annually. They go up every January. You'll notice here for this year in 2024, if you are an employer with 100 or more workers, you would need to spend $3.51 per hour, and that's for each employee. Also, if you're an employer with 20 to 99 workers or a nonprofit with 50 to 99, then the spending rate this year is $2.34 per hour for each covered employee. And I'll talk about what that per hour means just a little later in this presentation. Okay, so to satisfy this spending requirement, employers must spend at the applicable rate for its size that we've looked at, and then you must use the amount of hours that the employee works. So to find the spending requirement for each employee, you would multiply the expenditure rate by the number of payable hours the employee earned during that quarter. And let's talk a little bit about payable hours. Payable hours include, of course, the hours which the person worked in San Francisco, but it also includes hours for which a person is entitled to be paid. So if you have an employee working overtime or using paid time off or paid vacation hours or paid sick leave during a quarter, all of those hours are payable. There is a maximum. The total hours for this spending requirement is capped at 172 per month. So, if you have an employee that's working a lot of overtime in San Francisco one month, maybe because of a big project, they work 200 hours, the employer, you're only required to spend up to the cap amount of 172 hours. You don't have to spend more than that. And this slide, it really demonstrates the cost for a full-time employee. So let's look at it. To calculate the spend for this year, 2024, for an employer with 100 or more workers, you would use the maximum hours of 172, and you will multiply that by the rate of $3.51, which will give you a healthcare spend of $603.72 a month, or $1,811.16 for this full-time employee during that quarter. And the same formula goes for a medium-sized employer. You would use, however, you would use the applicable hourly rate. So the hourly rate for 2024 for a medium-sized employer is $2.34 per hour. So if the worker is full-time, you will multiply the 172 hours, which is the maximum, by $2.34, the hourly rate for the medium employer. And the employer must spend $402.48 a month, or $1,207.44 by the end of the quarter for this employee. So these are the rates for the full-time workers. If you have a part-time worker, you're spending, maybe half, because that worker wouldn't have as many payable hours. And also remember that this is a San Francisco ordinance. So if you're an employer and you have workers that maybe work some hours in other cities, maybe Oakland, and some of their hours in San Francisco, you only need to spend based upon the hours that they work in San Francisco. Now, there are some different ways to satisfy the spending requirement, and let's talk about those. Okay. Health insurance. Health insurance is the most common way to satisfy the spending requirement. I'm sure many of you employers pay medical, dental, or vision premiums now, perhaps to satisfy other legal obligations or to attract or retain employees. So if you are spending money on insurance, you need to just look at how much the cost you are spending for your employees to see if it is in compliance with the HCSO spending requirement. But any payments that you make for medical, dental, or vision insurance for your covered employees or their spouse, partner, or dependents would all count towards employer spending. I want to emphasize, though only the employer spending counts. So let's say the employee and the employer's medical plan for themselves and their partners, there's a cost share, which is permissible. And, oftentimes employers do that. It's very common to share the cost with their employees. Let's say the employer pays half, 50%, and the employee pays 50% of the medical premiums. So if this plan costs $1,000, only the $500 spent by the employer would count towards the spending requirement, not what the employee is contributing. Another way besides health insurance to satisfy the spending requirement, which is also very common compliance mechanism, is the San Francisco City Options MRA program. The San Francisco City Option is managed by the Department of Public Health, not by OLSC. OLSC doesn't run the program. We enforce the spending requirement. But the San Francisco City Options MRA program is a way employers can make contributions for covered employees to comply with this law. Another option is any spending on health savings account, HSAs, or medical savings accounts, or any other irrevocable account that you may have where employers are making contributions and it can never return back to the business. I want to caution you though, flexible savings account, FSAs do not count because we know those plans are, use it or lose it. So that's not an irrevocable account. But most often what we see is that employers use a combination of these. We see, for example, an employer may have a very generous health plan for its full-time employees, and it determines that what it spends on its health insurance does satisfy the spending rate, but they may have part-time employees who are not eligible for their employer plans. So these employers will need to find a different way to make contributions for those part-time employees. And so sometimes we often see employers make contributions to San Francisco City Option for their part-time workforce. We also see employers doing maybe a combination for one employee. If an employer is supposed to spend the $603.72 a month, and the employee shares the cost of an insurance plan, and the employer is contributing $300 a month, then the employer needs to find another way to satisfy the spending requirement of the additional $303.72. And here again, for that particular employee, they may get health benefits and they may also get some contributions to San Francisco City Options. We often also see, of course, that employers have HSA health savings plans attached to make healthcare expenditures, and we have seen employers, maybe they offer different health plans and find that some of those plans are cheaper for some employees, and they may require additional expenditure. They may, satisfy the spending rate for some employees, but not others. So they need to find, a different way to satisfy the spending requirement, and maybe making those HSA contributions is a way to do that as well. Okay, so the deadline for these spending requirements, you know how to calculate it and who is eligible for them. So when are the spending requirements? What is the deadline? Well, the law only requires employers to make this analysis quarterly. You only have to do it 4 times a year. As a covered employer, you have 30 days following the end of the quarter to analyze the spending and to make any necessary contributions. So the deadlines are here: April 30th, July 30th, October 30th, and January 30th. So let's just say in January, what you would do is as employers, you would go back and look at how much you spent on insurance in October, November, and December. And if you discover that you have not fulfilled the spending requirement for all of your San Francisco covered employees, then you can make those additional healthcare expenditures if needed. You have an additional 30 days either to contribute to their HSAs or San Francisco City Option or another irrevocable reimbursement account to comply with the quarterly deadline of January 30th. Okay, let's get into the second obligation. The second obligation for employers is a mandatory poster requirement. You'll find in all of the laws OLSE enforces, we have some sort of poster requirement. This is a copy of the 2024 notice. The poster changes every year, so employees can see what the current rates are. So every covered employer should post this in a conspicuous space if you have a San Francisco workplace or job site where your covered employees work. But if you don't have a location, that's, in your control, like the employees working at their home, then you can just provide this OLSC notice to them via email, or if you have intranet, you can post it there, or you can mail it to them every year. You just need to notify them of their rights under this law. And this poster is available in different languages. It's typically double-sided, but it comes in English, Spanish, Chinese, and Tagalog. Okay, the third obligation for employers, this is pretty straightforward. This requirement is for employers to keep for a period of 4 years each covered employee's payable hours. So, well, a few things, payable hours being the first one I'm mentioning here. So they'll also want to keep record of any paid healthcare invoices. So if you are making healthcare payments, you definitely want to keep a copy of those invoices that you paid, and any enrollment documentation showing you when the employee enrolled in the plan and which plan they're on. If you have any healthcare HCSO voluntary waiver forms, which I'll get into a little bit later, you definitely want to keep copies of those in your compliance records. You'll want to keep copies of any payments you made to San Francisco City Option, any contributions that you sent in for your employees there, or any other irrevocable account for the employees' health care. Any documentation that demonstrates your compliance, it may be work locations or start and end dates. You should probably keep these records, I'm sure you do, to comply with other San Francisco labor laws, but you should want to keep them also where you can easily access them, because if you are audited by our office, we'll call you, and we'll want to inquire from you what you're doing about healthcare compliance. And there's oftentimes too that employees want to know how you're complying with this law. So having those records easily accessible and available to be able to show is something that you would want to do as a covered employer. Like I mentioned, our office does audit, and if we do audit, we're going to ask you to go back 3 years and to provide us with your compliance records. Okay, the fourth obligation for employers, we discussed the spending requirement, the poster, and the records requirement. So this final requirement is the annual reporting form. The annual reporting form is due to OLSC by April 30th of each year. The purpose of this reporting form is to really just show the total healthcare spending that was done for your San Francisco workers, and to show the different ways you complied with the law. Because this form can be confusing, we do offer a live webinar each year in April to help employers understand how to complete it. Well, we usually offer it, I believe, in March, to help employers know how to complete it in April. We also have additional webinars on our website now, and other resources that are available, that you can look for information if you want to, understand that before that live webinar. If you go to our website and just search annual reporting form or ARF, you'll be able to find that information. Oh my goodness, sorry. Okay. Along with the annual reporting form, I wanted to just say that we send this notice out when it's due to whatever address your business has recorded with the San Francisco Treasurer and Tax Collector Office. And to anyone that actually registers for our OLSC email list. So if you do one of those two things, then you will receive the notice regarding when this form will be due. So this will wrap up the employer obligations. Now I am going to talk about some exemptions. Okay. And I have these exemptions broken down into 3 parts. So Here is the first one. There are very few employees. I just want to say this. There are very few employees that are exempted or excluded from eligibility under HCSO. Now, because these exemptions are rare, it's best to assume that all of your San Francisco employees are covered by HCSO and are entitled to healthcare spending. But since there are a few exemptions, let's talk about them, okay? So the first one here are for your employees who are eligible for Medicare or TRICARE. So if you have employees who are over the age of 65, they're most likely eligible for Medicare. And if they're eligible for Medicare, those employees would be exempt from this law. This means you as an employer, you don't have to, you have no spending requirement for them, healthcare spending requirement for them. TRICARE, which is a specific healthcare program run by the VA. If you have employees who receive TRICARE, you don't have to spend on them. Now, this exemption is specifically for Medicare and TRICARE. So if you have employees on other government health run programs like Medi-Cal, which is California's Medicaid program, or they're on other veterans programs, they are still covered by HCSO. They are still entitled to healthcare spending. So this exemption is very narrow. It's just for Medicare only and TRICARE only. Okay, also quite rare are employers with contracts or leases with the city and county of San Francisco. They may be exempt from HCSO. So if some of your funding comes from contracts or services with the city of San Francisco, or if you lease property from the city of San Francisco, you are probably supposed to comply with the Healthcare Accountability Ordinance, HCAO, and not with HCSO. So if you are a city contractor or leasee, you should know about HCAO and which of your employees are covered by it. You know, you may have some employees that fall under HCAO and under HCSO. But if you have any questions, you can always call our office. And if you don't have a city contract or lease property with the city, then you can just ignore this exemption because it would never apply. Okay, next. Also, also quite rare too is an exemption. We rarely see this exemption. It is for nonprofit employers with a specific training program. Now, this training program, there's a federal law that defines what this program is, and it limits the positions that can be exempt. So if you're a nonprofit and you think that you have people that fit in this category, please give us a call so that we can advise you, as we rarely see this exemption. Now, this exemption I'll discuss now, this often causes some confusion, so I may repeat myself through this slide. This exemption is for certain managers or supervisor employees. They may be exempt from HCSO spending requirement. So managers and supervisors who in 2024 earn a salary of $121,327, and in addition to meeting the salary threshold, the manager and supervisor also satisfies the HCSO definition of a managerial or supervisor employee. Now, the HCSO definition for manager and supervisor is different from many other laws, including the California state law. Simply having the word manager or supervisor in someone's title is not enough for them to be exempt from this law. I would suggest always contact our office if you are in doubt. Don't assume that your highly paid employees are exempt. Refrain from assuming, the person that has a title that sounds high level is going to be exempt. The definition of manager and supervisor is pretty narrow. It's for employees like your CEOs or CFOs, your pretty high level managers. We sometimes see employers trying to claim, all of their project managers are exempt. Salary amounts in San Francisco in particular can be quite high. A lot of times we see employers with most of their staff with salary amounts that meet the requirement, but that doesn't mean that these employees also meet the definition of manager or supervisor. So to be exempt, the employee must have a high degree of authority or discretion within the company and meet the salary requirement. It's not just the job title, it's the job duty. We've also seen, where employers slap VP titles on every single salesperson and claim that they're exempt, but we find out that they have no discretion with it or no authority within the company. They just have a fancy title. So we sometimes have to get into the looking at job descriptions and interviewing workers within the organization to find out what their role was within the company. The safest bet is, to reserve this exemption for the very, very highest few within your organization and assume everyone else is covered. This exemption is intentionally narrow, but you can always contact us, always contact OLSC HCSO hotline for more, information or clarification on this. Okay, the other exemption that causes confusion is employees who sign the HCSO Healthcare Security Voluntary Waiver Form. So I want to remind everyone again that a covered employee is someone who works 8 hours a week on average in a quarter in San Francisco and has worked for the company for 90 days. It has nothing to do with whether the person has insurance or not. So you can have an employee who already has insurance and they're still covered by this law and entitled to health care expenditures. You can have an employee who has insurance with their spouse's employer. They are still covered by the law and entitled to health care expenditures. You can have an employee maybe that pays for their own insurance out of their pocket. They're covered by the law and entitled to health care spending. That's the rule. The limited exception to this rule is you can have an employee sign a health care security ordinance voluntary waiver form. Now, the HCSO waiver form, this is different from the form that you may turn in to your administrator or your insurance provider saying someone doesn't want insurance. That's not waiving rights under the HCSO spending requirement. That's simply the employee opting out of insurance. So to protect yourself as an employer, if you have someone willing to waive their rights under HCSO, meaning this person has health care benefits from another employer, they've read the HCSO waiver form, they understand they have a right to an alternative expenditure, and they still say that they don't want it, then you can ask them to sign the waiver form. A completed OLSC waiver form is valid for 1 year. It can, however, be revoked at any time by the employee. And I want to mention while we're discussing this waiver that there are some exclusions. There are some employees that should not sign this waiver. So if your employee has health care benefits if your employee does not have health care benefits from another employer, for example, the employee is paying for their own insurance like Kaiser, or they're receiving insurance from a government program like Medi-Cal, or maybe they're uninsured, then they can't sign the waiver. If they are not getting insurance from another employer, the employer, their current employer, is required to make the minimum health care expenditures for that employee. Those employees who do sign the waiver, they're typically enrolled in insurance, maybe with their spouse or another job. But I will say, even with employees in that circumstance, it's very rare that you will find someone that's still willing to give up their rights to receive this expenditure. We expect to just see, a handful of HCSO waivers if for any given workforce. These waivers are really the exception. They are not the rule. Okay, so some other issues, some other matters involving HCSO. There are employers who have self-funded plans, and these plans can be medical, dental, or vision plans. Covered employees, as a covered employer, you're still required to meet the hourly spending rate. However, because of the rules and the calculations for self-funded plans are slightly different than traditional fully funded plans, if you're a covered employer with these self-funded plans, you do not have to comply with the quarterly spending deadlines. Employers with self-funded plans, you should do your calculations for your employees who are enrolled in these self-funded plans at the end of each year. And if you do have to make a necessary top-up, that would be made the following February. But I'm not going to really get into how you calculate the self-funded plans in this presentation. Self-funded plans are complex enough to have its own webinar. We offer the self-funded webinar every year to help employers that have self-funded plans figure out how they can comply. If you are an employer who has some employees, some of your San Francisco workers on your self-funded health plans and some on your traditional plans, then you need to comply with the quarterly spending for those employees enrolled in your traditional plans, and then make the review of your self-funded plans at the end of the calendar year. Okay, another issue that we get asked about are surcharges. So HCSO, the law, it doesn't prohibit nor does it require employers to pass on the cost of HCSO to its customers. A business can choose to charge a customer for the cost to comply with the law if it wants. It certainly is not required by the statute. If you do choose to implement a surcharge to cover whole or part of the HCSO requirement, you must ensure that the money is spent on healthcare coverage for your covered employees. We have seen, many cases where, an employer is charging 5% on every single bill and not spending anything on the employee's health care. That's a real big red flag for us. That's going to require enforcement action. So if you're a business and you are charging extra for this compliance, you need to make sure that you're tracking the amount collected from the surcharge for the covered employees' health care and the amount you're spending on the covered employees' health care. This is something that we will ask you about in an audit. We will ask for documentation about where the money went. We would want to see your records of everything that comes in and what goes out so that you can, justify the surcharge. Okay, now let's get to some common compliance issues. So this will not happen to you, but this is a list of some of the things that we see every day. failing to make any healthcare expenditures for covered employees. Sometimes this happens because employers aren't aware of the law. Or sometimes this happens because there's been a transition in HR or the benefits department, and the person that used to oversee the compliance is gone, and so the ball got dropped. Another thing we see is spending too little on health care. So it's not just about having a health plan, it's about how much you're spending on it. Some employers mistakenly believe that simply having a health plan means that they comply with HCSO. However, the key factor is the amount you spend, how much that health plan costs. Another compliance issue we see is disregarding part-time workers. Forgetting about part-time employees is a big one. Employers that are nationwide tend to offer full-time workers benefit and not part-timers. But if you have part-timers in San Francisco, you need to spend money on those workers' health care. So that's a big area where we see employers slip up. Also, assuming employees are exempt from HCSO when they have, just assuming that they're, and this is, assuming employees, are exempt from HCSO is something we often see happen with the HCSO voluntary waiver forms, when the employers don't have good clarification as to who are eligible to sign these or not. So making assumptions about who can sign these and being wrong on that can often lead to a compliance issue. Also, failing to make expenditures for employees with other coverage. We often hear employers say, oh, I've forgotten that I didn't make contributions for her because she was on her spouse's policy. I didn't think I had to do anything else. And so that's not true. Remember that covered employees are those that have worked for the employer for 90 days and that work an average of 8 hours per week in San Francisco during a quarter. So whether or not they have insurance or not does not matter. The law would cover a person who does have insurance under their spouse, unless there is some type of an exemption in place. And then the last compliance issue that we see a lot are with surcharges. So if you collect extra money from customers, you need to ensure that it's been spent on healthcare, and you should have records to show that you're spending this on healthcare. Oh, sorry, y'all. Okay, so just that we are clear, there can be consequences. Didn't mean to skip this slide. So employers can face consequences or enforcement actions included but not limited to audits, assessments of restitution, interests and penalties, administrative hearings, and there can be court action. But one of the reasons we have an online library, one of the reasons that we reach out to employers, one of the reasons that we have a technical hotline for employers to call us is that we want to be able to help you comply. We will not punish employers who reach out to us and ask us for help. If you realize during this presentation that you're out of compliance, or this is the first time that you've heard about this law and you're worried about how to fix it, please give us a call. We want to give you guidance. It's better for you as an employer to call us. It's better for you to take proactive action and ask questions to address your compliance issue than for you to get an audit letter from us because you had a worker call us and complain about the healthcare spending. We will, if you call us, we will provide you with a resolution. We will give you a remedy. We will offer you solutions. It's always better for the employer to ask for help to fix the issue rather than OLSC to take enforcement action. Breaking the law, can have consequences, but we are here, we are here as a resource. We are here to ensure that you don't have any compliance issues. Okay. Now I am going to get into some frequently asked questions because that concludes the presentation, and we're just going to talk about, I think I have 7 questions here of things we see often and I want to share with you. Okay, so I offer insurance to my San Francisco workers. Isn't that enough? Well, not necessarily. As I mentioned in this presentation, the employer has to ensure that the insurance is sufficiently expensive to satisfy the spending requirement for that year. So, and then also the employer has to make sure that all of the employees in San Francisco are actually enrolled. So if the insurance is not expensive enough, or if all the covered employees are not accounted for, then you need to do more. Just offering the insurance plan is not enough. You may need to make some contributions to San Francisco City Option for your part-time workers, or top off your insurance payments by making those contributions as well. Okay, the next 2 questions here. The first one, do I need to make healthcare expenditures for employees who already have insurance? Yes, unless there is a waiver or one of those exemptions, but most of the times, yes. Okay, and then the second question here is, what do I do if I've offered insurance and the employee doesn't want it? Well, I would say, insurance is one way to comply. Most often, you would need to find another way to comply. And some of those other options are making contributions to San Francisco City Option, or making contributions to another medical reimbursement account, or another irrevocable account for your employees by the end of the quarter. Okay, 2 more questions here. What is the difference between the HCSO and the San Francisco City Options? Okay, we get this a lot. HCSO is the law itself. It requires spending. The City Options is a healthcare program. It's one way employers can comply by making contributions for its uncovered employees to that program. Okay, the next question here, it says, what is City Options and what do my employees get when I contribute? Well, City Options, again, is a program managed by the Department of Public Health. And when you make contributions for your employees, they go into a medical reimbursement account individually allocated for them, that they can tap into to get reimbursements for any out-of-pocket medical expenses that they may have. And your employees get this regardless if they have, other health insurance. Okay, 2 more questions here. I thought I only had to worry about employees who aren't on my health plan. Well, that's not true. All of your San Francisco workforce is covered by this law. So if your health plan is compliant with the spending requirement, then your covered employees, then you are doing enough. That is good. But if your health plan is not sufficient, you will need to find another way to make expenditures for those employees who are not enrolled in the plan or do not satisfy the spending requirement. The second question on this slide says, does this law apply only to people who live in San Francisco? And so no, the place of residence doesn't matter. It's where the work is performed. So this law is about the work location, where your workers are actually performing the work. Now, if they actually are performing the work where they live, then yes, you would consider their place of residence. Okay. Do I have to comply with this for my highly paid employees? Yes. Again, a covered employee is someone that works 8 hours, averages 8 hours per week in San Francisco during a quarter, and that has been employed 90 days. So it doesn't say that their salary has to be a certain amount. You can have an employee making $300,000 a year, and they are still covered by this law unless one of those exemptions applies. Waivers. I'm confused about waivers. When are they required? Well, they're never required. So again, they will be used in very rare situations where someone has insurance from another employer and they're willing to sign their rights for this additional expenditure. So this is the exception, not the rule. Okay, and then where can I find more information? You can sign up to receive information on our HSO link. We have a website where you can sign up to receive updates. You can also visit our website to get look at our administrative guidance, which is listed like frequently asked questions. On our website also has the waiver form and annual reporting form. We offer a monthly webinar that you can attend, and you can always give us a call to get your questions answered or to let us direct you to additional resources. So that will conclude my part of the presentation. I will like to hear from Beverly with some of the live questions that you all have.
Well, folks, please, if you haven't done so already, go ahead and put questions in that question and answers box. I think, as you could see, Gabrielle has preempted and answered some of the questions that you might have put into that box, but OLSC HCSO staff will respond to you individually if you have not received an answer in the session. And they will respond to you at the email address that you used to register for this particular webinar. So with that said, Gabrielle, we do have some questions. And the first question is that, what if I had an employee who started on April 6th? When should I start making the healthcare expenditures?
Okay, thank you, Beverly, for the question, and whoever asked that. If you have someone working on April 6th, then they're eligible in 90 days. So you would want to find what day is 90 days from April 6th. You can put that in your search box and on your internet, and it'll give you a date. If that date is anything other than the first of the month, you can wait to the first of the following month to begin making your calculations. So in this example, if they started April 6th, they would probably hit the 90th day about July 6th. So then that is not the first of the month. So you could wait until August 1st to begin making your calculations. And then at the end of that quarter, August and September, you will want to count however many hours that they worked during that quarter and make that expenditure 30 days at the end of the quarter by October 30th for those 2 months.
Sounds like everybody should take notes per employee. That sounds great. This next question has to do with open enrollment. So this employer writes, we have open enrollment in October. If the employee signed the HCSO voluntary waiver form on October 15th, am I exempt from paying the healthcare expenditures for the entire month?
Okay, another good question. If the employee signed the HCSO waiver on October 15th, then yes, the employer is still responsible for healthcare expenditures October 1st through the 14th. I will say too that on the HCSO waiver form, it cannot be backdated. However, it can be future dated. So if your enrollment starts over the beginning of the year, you can make that enrollment to begin January 1st. So anytime that their employee is not eligible. So if it didn't begin to January 1st, then you'll be responsible for all of October and up through January 1st. But if they signed it October the 15th and you want to make it effective October the 15th, then you are responsible for October 1st or the 14th. You'll just want to add up all of those hours that they worked during that period. And if they worked an average of 8 hours, and if they've been there 90 days, then yes, you would want to make expenditures for those days.
Thank you. This question is about the geographic boundaries of the city and county of San Francisco. How do I know if my employees work within the geographic boundaries of the city and county of San Francisco?
The city of San Francisco and county, they're unique. They share the same boundaries. So if you have an employee and they're working at an address that is an address of San Francisco, then they are covered by this law and they are entitled to health care spending.
Thank you. This employer writes, what should I do if I have determined that my company has not complied with the HCSO at some point in the past few years?
Please give us a call. We are here to help you get into compliance. Reach out to us. Give us a call. Send us an email to arrange some time for us to talk with you, and we will offer you some ways in which you can come into compliance. Don't
This
be
one has
afraid.
to do, oh, sorry. This one has to do with the interaction between the HCSO and the HCAO, the contract healthcare requirement. How, the employer writes, how do I know whether the HCSO or the HCAO covers my employees?
Okay, if you have a contract with the city or city and county of San Francisco, or if you lease property with the city and county of San Francisco, then you're probably covered under HCAO. If you don't, then this law does not apply to you. You are not covered under HCAO if you do not have a contract or lease property with the city. But if you have questions, just give us a
Yeah,
call.
call us if you have any questions, if you're not sure. This one has to do about the annual reporting form. What do we do if our company has not filed the annual reporting form? I guess they didn't know about it.
Okay, yeah. Typically, we keep the link up for about a month after the due date. So at this time in the year, there's really no way to file it. What I encourage you to do as an employer is to keep the records of what you would have filed and on hand so that you can discuss that if there's a need to. But the most important thing is to make sure that you're adhering to the spending requirement and that you have documentation of showing how you're spending on your covered employees. Um, but if you did not meet the deadline, just try to sign up to ensure you receive the notice to do it next year and just keep records of what you were spending.
Keep records. That's really
Yes.
a good best practice. This next question is about the city option. If we decide to use the city option, how would our employees know that they have funds to use in the account? I guess at the city option.
Okay, as an employer, if you sign up and to make contributions for your employees through City Option, you would want to make them aware that that's what you're doing for them. So when you make that first contribution, San Francisco City Option has an employer portal. You can download a flyer to give to your employees that shows them how they can contact City Options to find out more information. But as the employer, you should notify your employees as soon as you make that initial contribution that this is how you're adhering to the ordinance, and they have the information to follow up with City Option to get into their account.
How about this one? Our employees work hybrid schedules. If they take vacation, how do I determine the amount of their healthcare expenditures while they're on vacation?
Okay, that's a good question. So, if your employees spend some of their working hours in San Francisco and some of them in a different city, and they go on vacation, then whatever days that they usually work in San Francisco, you would want to also count those days as their vacation days. So if they're off a week and they usually work in the city of San Francisco 2 days, then you would want to count those 2 days as their health care when you're calculating their health care expenditures during their vacation time.
Well, that's all the time we have for, and we do have some questions that staff was unable to answer. And if you've been joining us for the whole day, thank you for sticking around. I want to thank Gabrielle for the HCSO presentation and just remind everyone that if you have a question that wasn't answered in the question and answers box, we will contact you in the next few days with an answer, and you will get that information at the email address you registered for this webinar. We actually have almost 300 questions that's come in since the start of this webinar, and I can see that there are some questions that we were unable to answer, but I really hope by listening to the presentation, you are able to find the answer, but we'll contact you soon. Thanks again, Gabrielle.
Thank you.
So folks, we are at the top of the hour. We're going to get started. Welcome for everyone who are joining us to this particular session, to the Citywide Labor Laws webinar for all employers operating and doing business in the city and county of San Francisco. This webinar is hosted by the Office of Labor Standards Enforcement, also known as OLSC. Thank you for joining us, and my name is Beverly Popek. I'm a supervising compliance officer at the Office of Labor Standards and your host for the day. Our office is here to help you understand your labor compliance requirements. So this is session 6, the Family Friendly Workplace Ordinance. If you're returning from a previous session, welcome back. We hope you can join us for this session as well as just the one last session at the very end. The schedule is published on our website and also on the WebEx registration page. So please open up the chat box, the bottom right-hand side. You can access that chat box and you'll see the URL with today's schedule for the final presentations. Before we get to the presentation, I'd like to go through some of the features of our WebEx webinar to help you get more out of this event. First, the slide deck and a recording of this webinar will be available on our website in a few days. And again, our chat box, bottom right-hand side, you should open that up to see public announcements and helpful information that complement the presentation. So how can you ask questions and get answers? Today, we have a questions and answers box feature available for you to use. Just send us your questions through this box during the presentation, and staff will do their best to publish an answer. Some questions may require more information, and you may be asked to contact us. Also, if you don't get an answer during the webinar, our staff will contact you in the next few days at the email address you use to register for this webinar, to set up a time to meet or provide a comprehensive answer that's just not possible during today's session. And at the very end of the presentation, at the end of the session, we will have a live question and answer session in which staff will select your questions to be answered live by the presenter. I just want to be clear that this presentation and for the entire webinar today, it's not intended, the information is not intended for companies who operate at the San Francisco International Airport, also known as SFO. Citywide labor laws do not apply to the airport because the airport is not located in the city and county of San Francisco. So here we are at session 6, the Family Friendly Workplace Ordinance. I'm your host and presenter, Beverly Popek. Jade San Diego is your co-host and also working in the questions and answers box. And Sally Chin is in the chat box. So let's get started with an overview of what we're going to do here for the Family Friendly Workplace Ordinance presentation. I'm going to go through the employee rights, who's a covered employer, and the requirements of the Family Friendly Workplace Ordinance, best practices, and then we'll wrap up the presentation with resources that we have available. This slide is about the legislative history. And we have this here because the family-friendly workplace ordinance, it's been around since 2013, as you can see. But there was a change to this particular ordinance in 2022 when the Board of Supervisors amended the ordinance. And what it did, it changed the ordinance from giving employees the right to request an arrangement to the right to an arrangement unless an employer is able to demonstrate an undue hardship. Now, all of this is going to be unpacked later, and I'm a little repetitive, so I will repeat that. But that is really the big change. And as I said, this particular ordinance has been around since 2013, but this change makes this ordinance completely different. So let's take a look at the employee rights. As mentioned, the amendment really changed the employee rights, and it gives the employee the right to request the right to an arrangement unless you, the employer, is able to demonstrate undue hardship. And we'll really define and give you some good examples of what undue hardship is, and if that's the case, more about that process. So in terms of employee rights, the family-friendly workplace ordinance is really defined here for covered employees the right to a flexible or predictable working arrangement to assist with caregiving responsibilities for the following three items. And this could be singly or. So number one, a child or children for whom the employee has assumed parental responsibility. Number two, it could be a person or persons with serious health condition in a family relationship. And we'll talk about how we define family relationship in just a minute. And with the caregiver. And third, a person who is over age 65 or older in a family relationship with the caregiver. So the employee is the caregiver, and if they're in a family relationship, which means a relationship related to the caregiver by blood, legal custody, marriage, or domestic partnership, that employee has the right to a flexible or predictable working arrangement to assist with any or all of these folks if they so desire to make that arrangement with you. Now, if you've been with us all day, you know that you have to understand if you are a covered employer. A covered employer is a company with 20 or more employees anywhere in the world. That does count part-time folks, and if you have workers in which you employ through arrangements and you're not sure if they're employees or not, take a look at the IRS definition of what an employee is and that pinpoint test. Now, so that's the first part. The second part is that a covered employer must have a business location within the geographic boundaries of the city and county of San Francisco. So if you're not local, if you're not familiar with the city and county of San Francisco, you should look this up on the internet. And please, if you have questions, directly call the unit, the FFWO unit, to understand more. And let's unpack a business location. The definition of a business location is any physical space used for the business to run its operations. So that is essentially what would define who is a covered employer. Now, if you have fluctuating employees, we have a document called the Rules and Regulations found on our FFW webpage. And if you look at Rule 1.2, you can find some information about fluctuating employees if that's the case, if you're up and down among and between near the 20. So now that you know if you're covered, and I'm assuming you are, let's understand who are these covered employees. A covered employee is someone who works at least 8 hours per week within the geographic boundaries of San Francisco, and with those boundaries extending to telework if the employee is assigned to the San Francisco business location. And number two, the covered employee has been employed by the covered employer for 6 months or more. So those are pretty clear cut, but this is a new aspect of the ordinance that was created in 2022, expanding the geographic boundaries, including those who telework. So this slide really unpacks and explains this more about employees who telework. Employees are covered by this law if they are assigned to a San Francisco business location at the time of the request is made, regardless of where they're physically working. So telework, people working from home at a distance. So if I am located in Denver, Colorado, but I'm assigned to a San Francisco business location and I make it, and at the time of request for this particular arrangement, I am assigned to the San Francisco business location, then I am covered under the family-friendly workplace ordinance, what we're discussing, you're learning about right now. So this is a big thing to understand. And then something else to keep in mind is that an employee is not covered by the FFW if they were never assigned to the San Francisco office. So for example, what if I'm located in Minneapolis, Minnesota, and my company has people who work in San Francisco, California, and even these telework people who are assigned to the San Francisco business location, but I'm in Minneapolis and I'm like, hey, I understand there's this FFWO thing. I want to make a request. I want to have an arrangement. But if I was never assigned to the San Francisco business location, I am not eligible and I'm not covered under the FFWO. If you want some more information about telework and understanding more about the different factors to consider if you have folks that telework, you should see Rule 2.3 in the Rules and Regulations document for the Family-Friendly Workplace Ordinance, and that's going to help you understand more about this. So with that said, let's dive into the requirements of the FFWO. And this first section here is, what does the Family-Friendly Workplace Ordinance require the employer to do? So number one, what you need to do at bare minimum, and this is high level, and we're going to unpack and get into the details a little later, is that once you receive a completed written request, you need to review and determine if you can provide the employee with the flexible or predictable work arrangement to assist in caregiving for any of those covered members there. Their children, family members with a serious condition, or a family member 65 years, or as requested. Now, number two, if you don't agree to the request, you need to engage in a good faith interactive process to determine a mutually agreeable arrangement. And three, if after considering the alternative arrangements that you and the employee brainstorm, discuss, things like that in that interactive engagement, and you're still unable to accommodate the request, you must notify the employee in writing that you can't accommodate, and you must explain the undue hardship determination, as well as give information to the employee about the right to request a consideration and possibly file a complaint with the Office of Labor Standards Enforcement. So at a very high level, these three items that I just went through explain what the Family-Friendly Workplace Ordinance requires you as an employer to do. Now, this next slide, I know you're going to be overwhelmed because this is also a process law. This particular chart here that you see here can be found on the Family-Friendly Workplace Ordinance webpage. This is extremely important, and I'm showing you this not for you to read it right now and go into every single box and arrow, but for you to understand that this resource is available to you, and the remaining next sections of this presentation, I will go through every single step and really what you need to understand about the Family-Friendly Workplace Ordinance in detail. So number one, notices and posters. You need to print out the official family-friendly workplace notice or poster. It's the same thing. And you need to put it somewhere, post it in your break room, a place where all employees can see this. Now, obviously, if you have employees who are remote, you can always email this information to them. Printable versions of the notice and posters are available in multiple languages and can be found on our webpage. Now, if you have a workforce where there's a language spoken by 5% or more that's not covered and translated on our webpage, you are responsible for translating the form and providing it to the workforce. And just as a follow-up, before I go to the next slide, the notice or poster is available in English, Spanish, Chinese, and Filipino. One more item on the notices and posters is that you must provide employees with the family-friendly workplace ordinance request form or a comparable form within a reasonable amount of time after the employee inquired about the accommodation. So big bullet point here on this first one is that a sample form, request form, is available on our webpage. If you have a form already, please make sure that your form is in compliance and it has similar matching information with this FFWO sample form, because the reason why we put together the sample form is useful, helpful information to determine a lot of these things that we have in the process and details. That's going to be very, very important, especially if there's any questions that come up, and also information that you really need to know to determine whether or not you can accommodate or perhaps have an undue hardship. The second bullet point is you need to provide a copy of the form to current and new employees, and you must add the policy, this family-friendly workplace ordinance policy, to your handbook when your handbook's updated. So if you don't have the notices up, you don't have a sample form or a form, please go to our website and take a look. Make it your own, or you can use it. It's up to you, but there are resources there for you. So once someone is making a request, let's really discuss that part of the process. The request that an employee makes must be in writing. A lot of times we as humans, we're very social, and sometimes it's more comfortable to ask things verbally and to chat about it, to discuss it. That's all fine, but ultimately the request must be made in writing, and you as employer, you must instruct that employee making a family-friendly ordinance, arrangement, request, etc. It must be in writing, and you should have a form to give them. Give them the form, do not delay, and just let them know that they must submit this in writing. And thank you for telling me, thank you for asking me, but please put this in writing. Now, number two, the request must be for caregiving responsibilities as defined under the law. So if it's a request and it's for something else not under caregiving and not defined under the family friendly, then this is not a family friendly request. Maybe it's just a change in schedule request. So you need to really understand and know that before you start the family friendly process. So you must understand what this process is for and who has a right to it, and you should ensure and make sure that they start the right process. So if they're not entitled and they're not really making a family-friendly workplace ordinance request, do not have them make a request under this process. Because as you could see for the rest of the presentation, there's a lot of details involved. So that's a tip there. Number three, part of the request must explain how the request is related to caregiving. And this needs to be somewhat specific, but you have to understand you cannot ask for confidential, sensitive information in regards to perhaps one's condition. and things like that, medical condition, let's say. So for example, the request must say, well, I need to pick up and drop off my 2 children, and I need to drive them. Here is where I live. Here is where the school is. Oh, there's 2 schools, and here is where our our office is. And based upon the commute time, the pickup and drop off time, and my schedule, this is the request that I, as an employer, looking for. The employee needs to really unpack it, and they're going to need help explaining that. So if they're not really clear on how the request is related to caregiving, you have a right as an employer to receive the request form, but to send it back and say, we need some more information. We don't understand. How is the request related to caregiving? You need to give us more information. Another common example that I've heard from employers and I've seen is that I'm requesting working from home an extra day because of my elderly mom. She's elderly, she's old, and she needs care. That is not specific. It needs to be very specific in terms of perhaps location, schedules, times, and what time is the person working? What time is the person needing time off? When are they on? When are they off? When can you, as an employer, contact the employee and expect the employee to be working, et cetera, et cetera. So yeah, so the request must explain how the request is related to caregiving, and it has to be specific. And don't be afraid to ask for more information, and you should get that before you start the process of accepting, truly accepting the request form. Now, that is really point number 4. Now, point number 5 here about the request is that the request date needs to be said, meaning that the employee needs to say when do they want this to start. It should be at least 21 calendar days prior to the requested start date. So that is something that should be. However, life happens. This is not how the world works. People get sick. There are unexpected needs. And as an employer, just make the best efforts to make a timely decision. But if, you need, 21 days to issue a determination, the law allows you 21 days to issue a determination. So let's take a look at the review process. Once you receive a completed written request, you have 21 days to respond to the employee's request. And when I say completed, that means with all of the information that the Family-Friendly Workplace Ordinance, and I'm telling you today, how is the request tied to caregiving? Was the employee specific in terms of the schedule, the location? I mean, if there's multiple locations involved, if you need, if they're asking for things, they need to put that down. There could be proposal 1, proposal 2, have them brainstorm as much as possible. But once you understand this caregiving need, it's really going to help you engage in the next part of the process. Now, you do have a right to request verification, and we're going to discuss that more on the next slide. And just remember that the 21-day deadline may be extended if you have an agreement with the employee confirmed in writing. So let's just say that your employee is they started this process, but their direct supervisor or manager is on vacation, and you need a few more days. You can extend the deadline, this 21-day deadline, to respond to the employee's request, but you need to confirm it and put it in writing. With all of this, I really highly recommend you communicate. Sometimes, most of the times, verbal is always the best, but memorialize and summarize and have everything in writing after the fact so everyone's on the same page. So let's talk about verification. You do have a right to a verification, and if you want more information about this, you should take a look at Rule 4 and Rule 4.1. What you'd remember is that if the employee attestation of caregiving duties, you should accept it, but you can request verification in some limits, and you are able to provide a note confirming the obligation. The easiest one and to understand is, let's just say the employee is requesting that every Tuesdays in the afternoon from 2 o'clock till close of business, they cannot work. They're looking for a flexible schedule to make up the time, and that's why they're asking to work earlier on a Tuesday or something like that, because that employee has a standing medical appointment every Tuesday at 3 o'clock for their father, et cetera, et cetera. So you can imagine, I mean, with medical technology and everything in treatment, and it seems like a lot of people are going through treatment, we do have standing appointments in which you can have a predictable schedule, and you can ask to have a note confirming the obligation. Now, this is all within reason, and you may ask, but you may not ask for confirmation about the appointment for like other folks, like from the employee's family members. So maybe you know that there is a partner or spouse, there's a brother or something, and then you're like, well, can't your brother take mom or dad to the appointment? Or um, well, I want a letter. I want to confirm. No, that is not allowed where there's verification from family members. So when you receive the request, if you want to accommodate the request, then you should approve it and you should put it in writing. And remember, if you grant it, you must complete this within 21 days of receiving the employee's request. And when I say days, it's calendar days. It's not business days. So 21 calendar days. Now, if you cannot accommodate the requested arrangement, what do? You need to engage in an interactive process. And this is really trying to have you understand what an interactive process is. Both the employee and the employer must engage in an interactive process, and that could be verbal, and it could be in person, it could be virtual, so you can discuss and brainstorm alternative arrangements that satisfy the employee's caregiving need and that do not cause you, the employer, undue hardship. So remember, I said you really have to understand what the employee's caregiving needs are. Super important. And then you got to circle, highlight that, and keep that in focus of what is this person, what is my employee's caregiving need, and how can we make this work where we don't have undue hardship. Now, once you understand that, you go through this interactive process, and a light bulb pops up, you see that, oh, wow, there's an alternative arrangement that basically meets the employee's caregiving needs and it meets my needs, employer needs. You can approve an alternative arrangement, although that employee didn't request it. So let me be clear. As long as you approve an arrangement that meets the caregiving needs, you should just do that and you have met the requirements of the law. This ordinance doesn't have any sort of requirement for preference. So obviously the employee might prefer one arrangement or proposal over the other. There might be multiple ways to meet the caregiving need, and it's your job to really try to figure out that accommodation. So more about this interactive process. It has to be timely and good faith. Discuss it. I think the best process starts with oral and then with, of course, everything in writing to make sure that you're all on the same page. There needs to be some way of exchanging essential information without delay to really understand what are the caregiving needs and for you to determine, well, is there any other arrangement that you can possibly, um, approve and not have an undue hardship. That is, of course, if the original first arrangement that the employee is asking for has some sort of undue hardship for you. So you should analyze the functions and purpose of your employee's position in relation to the operations of your company, and you should consider the requested arrangement. But again, you can approve any sort of alternative arrangement that meets the employee's caregiving need. And this is, again, I keep saying this, but it's really important that you need to write down, and you should write down what the caregiving needs are and have the employee look at it. Say, hey, is this right? Am I understanding this correctly? Am I missing something here? So that you're all on the same page. And then again, if you provide an alternative arrangement that meets the caregiving need of the employee, you meet the requirements of this ordinance. And that's true even if the employee declines. So the employee could, at the end of the process, say, thank you, but no, thank you, for whatever reason. And that is kind of the end of this particular, arrangement and process. So if no agreement is met, you as the employer and you want to seek to deny the request, you must prove undue hardship. And undue hardship is the only reason you can deny a request. And this undue hardship, you have to be able to demonstrate that the request would cause significant expense or operational difficulty. Now, the law does not require you to alter or impede your business operations in a manner that would cause significant expense or operational difficulty. So keep that in mind. And here's, we're going to start to really unpack what undue hardship reason, the undue hardship reason, because that is the only reason for a denial. So undue hardship is defined as causing you, the employer, significant expense or operational difficulty when considered in relation to the size, financial resources, nature, or structure of your business. So if you are going to go down this path of denying, your denial must be in consideration of the most current arrangement the employee has requested. Whether it be in the original request or made during that interactive engagement of alternative arrangements that maybe you and the employee brainstormed and identified. Now, if you want to assert that you can only comply and grant a part or some of the requested arrangement, so for example, on the slide, we say you can reduce hours, but you cannot allow the employee to begin work earlier in the day without undue hardship, then what you need to do is you need to approve the parts, the provisions of the request that you can do. And for the parts of the request that you can't accommodate, you need to demonstrate undue hardship. And we're going to get more into this denial process, but that's the part where you'll unpack and you have to share why it's undue hardship. And it would be super, super clear which part is approved and which part you are denying to the employee. Now, every situation is unique and it is subject to individualized analysis, and you as an employer should consider your circumstances in determining whether you can or cannot do this undue hardship. So let's look at denying the request. And remember, the only reason you can use to deny the request is undue hardship, as explained prior. So you must explain the denial in writing, and it must have the following. So number one, you have to explain the basis of the denial and undue hardship. And think of it this way. If you're writing this and you're not exactly sure what to write, write it as if a third party like OLSC or someone else might be reading, so that any third party can clearly read it and understand why you're denying the request, what is the basis, and what is the undue hardship. Number two, make sure that in that denial document, that written response, you're notifying the employee of their rights to request a reconsideration if this is the first round or first part of the process, which is allowed. And then secondly, after filing the reconsideration, if you are unable to meet any part of the schedule that they are asking for, you need to let them know that the employee is able to file a complaint to the Office of Labor Standards, and you must include a copy of the poster with the final denial. So let's say we're going through the first pass here, and you're unable to grant because of undue hardship, and now the employee has a right to request for reconsideration. They have that right within 30 days after you issue the denial. And let's say that they put in another request. It's a request for reconsideration. Once you receive that request, you must meet with the employee within 21 days to discuss and reconsider the arrangement. And a lot of folks have a checkbox on the original FFWO request form, or where it's like new request or reconsideration request. So that's something you can consider as well. You don't need to have a separate and distinct reconsideration request form. And number three, after you meet with the employee within 21 days to discuss and reconsider the request, you must issue a decision, a final decision in writing within 14 days of the meeting. So there's a lot of days here, and not to worry, because when you're going through this process, you will have, I would highly recommend you print out the FFWO process chart, so you have all the days as an overview and you understand it. You can calendar it and keep on track and organize, as well as the slide deck here. And we also have other slide decks where everything is published with how many days must you, respond. So right now it might be a little bit overwhelming, but all of this is in writing. That's my point. So let's talk about the final denial. The final denial, what happens if you cannot approve a specific part of the request, of the arrangement that the employee wants? You need to provide a final decision in writing within 14 days of meeting, and you must provide that information regarding filing a complaint to OLSC. So more about employees, filing a complaint with OLSC. They've received a response from you and there was a denial of the arrangement, or perhaps the time frame elapsed without receiving a response from you, the employer. So we do get this a lot, where there's a lot of days there, depending on which part of the process. You could pick 21, 14 days, but if you as the employer have not given any sort of response to the employee within those time frames, employees have a right to contact OLSC. And one of the options we have here is that we can and will contact you, the employer, if the time frame has elapsed and you have not met the time requirement. Obviously, we want you to get to the end of the process to figure out whether to approve and what you can approve, or if you are going to deny, what you're going to deny, and come to the end of the process. And at that point in time, of course, the employee again may be able to file a complaint with the OLSC regarding challenging or questioning the undue hardship. So that gets us to enforcement penalties and appeal procedures. We have this information in our rules and regulations documents. I would take a look at Rule 8 and 10 for this information. And then I want to talk about some best practices. So the best practice with the family-friendly workplace ordinance is that you really need to understand what an interactive process is and what it isn't. And you must engage in an interactive process in attempt of good faith to determining all of the possibilities to meet the employee's caregiving need that's acceptable to them and, of course, to you, which would not produce an undue hardship. That cannot be done unless you really understand what the caregiving need is. And with that, you might even have to, of course, ask questions about locations and talk about commute time and where is this school or where is that medical facility? Because that might be all part of the process if the person is getting time off in the middle of the day or you're questioning why the start or end time is one way or another. So again, remember that the interactive process must be timely, good faith, and it's a discussion, whether orally or in writing. The best processes I've seen are both, starting orally and memorialized in writing. The ones that are in writing are very slow, difficult, and super frustrating for both sides, both the employer and employee, but you have an option. And of course, you should always feel free to meet and discuss the request with the employee, and everything should be memorialized in writing. Writing, and keep good notes, your emails, and when it comes to, if it comes to undue hardship, you need to keep notes and the information about your analysis. Maybe that involves calculations, staffing, other mitigating factors, whatever it is, you must save all documents involved in this process for at least 3 years. And remember that each situation is unique and subject to the individualized analysis. So now that we're coming towards the end, this information provided is really at kind of a lot high level with some details. The video on demand that we have in our video on demand library for the family-friendly workplace ordinance is different from this presentation. It's different because we really dive into a lot of specific examples and details that you probably would find helpful. But if you think this is great the way it is, this is wonderful. But if you want more information, I highly recommend looking at the video on demand for the FFWO. We also have the required poster or notice that you should have up, and as well as distributed. And you will have to eventually give to that employee if you are producing a denial. Then we also have this sample family-friendly workplace ordinance request form. This request form is just a sample, make it your own, and do what you want with it. The request form could be for the first request or the reconsideration request, just add a little box, and that's really helpful. The fourth bullet point, which is really, really super important, and we use in our office when we have questions to really track and understand where anyone, employer, employee, and both parties are in the process, is like where's everybody in this process, this family-friendly process chart. It really helps print out a copy, and if and when an arrangement request comes in, you should track it, and that'll keep you organized. We also have a rules and regulations document that I referred to. I think that's super helpful. In that document, there are examples that I think will find useful and would provide more information. Some of the examples are in the video on demand, but take a look there, and there's a lot of helpful information. All this can be found on our Family-Friendly Workplace Ordinance webpage, which is at the very bottom here in the URL. This is our contact information for the Family-Friendly Workplace Ordinance unit. Please feel free to reach out to us directly by phone or by email. This can be very overwhelming, but remember, it's a process, sort of law that you just need to understand the process and the different parts. And we have tools and resources here to help you. So with that said, we are in the live questions and answers session. If you haven't done so already and you have a question, put your question in the question and answers box, and we will do our best to send you an answer. And if you don't get a response by the end of the session, we will contact you in the next few days at the email address you registered for this particular webinar. Yes. So Jade, do we have some questions here? I think I saw some of your notes that things have come in.
Yes, thank you, Beverly. The first question, I think we went over this, but the question is, how does the FFWO work when we have an in-office requirement and the employee wants to work from home for a whole day because they have to pick up and drop off their child to school?
So yeah, this is a frequently asked question. It's a real life scenario. If you have an in-office work policy and requirement for folks and the caregiving need is to pick up and drop off, you need to figure out an arrangement that meets the caregiving need. For this example, or this person who asked the question, you have to figure out what time it is and where, I guess, the pickup and drop off happens relative to your work location, which would be San Francisco. So you can have an employee come in the middle of the day for this particular example where, okay, sure, they can maybe start early online, take time off to drop off. After dropping off the kid or kids, they come into the office, work maybe 5 hours, 4 hours. I don't know what time it is pickup, and then they can leave to pick up kids and then finish their day remotely, which is extended into the wee hours of the night. You're being flexible in terms of having that person work their 8-hour day in a hybrid nature to accommodate the caregiving need, which in this example I hear it's pick up and drop off. So yeah, I mean, you can be creative that way. Is that what the employee is asking for or will ask for? It's, a lot of times employees will ask, I just want to work from home because I have this arrangement and requirement. Um, and these are your options. Now, obviously, if it doesn't really matter, if you want to just, if you can do the arrangement and there's no undue hardship, you can. But if you have an in-office policy and everyone, is held equally to that, that's what you can do.
Okay, thank you. And then another frequently asked question, what if our main office is in Danville? So if they're operating outside of San Francisco, they have a construction job site in San Francisco, do they have to comply with the FFWO?
Yeah, so you need to take a look back at the slides regarding your business location, and it sounds like this person has a business location in San Francisco. So you would have to comply, but exactly who you'd have to comply, it's kind of unclear in the answer. So maybe for that particular person, we'll ask that person to call in and we can discuss it some more. So we need to just have some more details, but they are covered in sense of, yeah, you have to do this.
Okay, just to clarify, because there is another question, the FFWO would not apply to remote workers who live in San Francisco, but they don't have an office, like a physical business location and within the geographic boundaries of San Francisco, then they would not be covered, correct?
Right. So for this particular question, it sounds like, and I think you have the question in front of you. The employee lives and works in San Francisco, but the company does not have a business location in San Francisco, right?
Yes.
So I just put up this particular slide of who's a covered employer. So in this case, you would not be a covered employer because you do not have a business location within the geographic boundaries of the city and county of San Francisco. Yes, you have someone working remotely in San Francisco, but the business location is any physical space used for the business to run its operations, not a remote worker's let's just say home office.
Okay. Okay, thank you. Next question. What reasons can an employer deny an FFWO request? I mean, that's probably very big.
So it's super simple, yet maybe not that simple. The only reason you can deny the request is undue hardship. And undue hardship, we unpack that quite a bit in this presentation of really what it is. So let me see here. I think what I would have you do is take a look at this slide. Undue hardship is causing the employer significant expense or operational difficulty when considered in relation to the size, financial resources, nature, or structure of the employer's business. When you look at our documents online, that's basically what undue hardship is, and you have to make an individualized assessment to see whether or not there is undue hardship.
Okay. That makes sense. Okay. Next question. What if an employee's caregiving reason falls under FMLA or CFRA and the employee's is requesting an FFWO schedule? Do we have to give the employee an FFWO schedule? Or can we tell that employee that they need to use FMLA or CFRA?
So this is common, and I think I mentioned this at the very beginning that you have to determine whether or not the request that the employee is making is really a family-friendly request. If the reason for the leave and the arrangement qualifies under FMLA and or CFRA, then you as the employer can require the employee to exhaust those entitlements before pursuing an FFW accommodation. So you have the right to do that. And I hope you understand. Now, obviously, if the employee doesn't have any more entitlements for FMLA or CFRA, then their only recourse would be for FFW, and then you would have to go through the FFW process.
Okay. Next question. It says we have a security guard company. We are contracted by companies to provide specific hours. We have not received a request that would fall under this act, but if we did, how would we comply being under contract?
I'm sorry. So it's a security guard company.
And, yes.
And I'm assuming
they're asking how they would comply if they're under a contract.
Oh, okay. So I'm going to take some liberties. And if you did ask this question, or if you have a similar question, it's probably best to make an appointment and call, or let's just make an appointment so we can discuss some more particulars and details to go through all of the possibilities. But let's take some liberties and try to answer this. So let's say it's a security guard company and they have a contract where they have to provide customers security services for set times and hours. I mean, that is super clear. And then if an employee who is a security guard wants an arrangement, you as the employer need to factor in the requirements of your contract of when you're supposed to provide your services and this person's availability and perhaps locations. Maybe they want to change a location or things like that. And how will this affect scheduling and staffing for everyone. I don't know if this is a small company, a large company, but staffing is something that you certainly have to consider. What else am I not understanding about this? And I am taking some liberties, Jade.
I think the rest of the questions are all real specific, so we would need more information on that.
Oh, okay. All right. Well, then that's fine. I guess are there any other questions for family friendly?
No, I think we're good.
Okay, great. Well, thank you for joining us for session 6. We're going to take a short break, and we invite you to join us to our final session, which is session number 7, Paid Parental Leave Ordinance and Military Leave Pay Protection Act. And that's going to start at 1 o'clock. Thank you. Hello and welcome to the Citywide Labor Laws webinar for all employers operating and doing business in the City and County of San Francisco. This event is hosted by the Office of Labor Standards Enforcement, OLSC, and thank you for joining us. If you started out at the beginning of the day and you've made it to our final session, welcome and congrats. My name is Beverly Popek, and I'm a Supervising Compliance Officer with the Office of Labor Standards Enforcement and the host for the day. Our office is here to help you understand your labor compliance requirements. So this is session 7. It is our final session, Paid Parental Leave Ordinance and Military Pay Protection Act. So welcome back. And before we get started, I'd like to go through some of the features of our WebEx webinar to help you get more out of this webinar. First, the slide deck and a recording of this webinar will be available on our website in the next couple of days. And if you haven't done so already, please open up our chat box. It's on the bottom right. Open it up so you can see public announcements and helpful information that complements the presentation. How can you ask questions and get answers? Today, we have a questions and answers box feature that's available for you to use. Just send us your questions through this box during the presentation, and staff will do their best to publish an answer. Some questions may require more information, and you may be asked to contact us. Also, if you don't get an answer during the webinar, our staff will contact you in the next few days at the email address you use to register for this webinar to set up a time to meet or provide a more comprehensive answer that's just not possible today during the session. And at the very end of the presentations, at the end of this session, we will have a live question and answer session in which staff will select your questions to be answered live by the presenters. I want to be clear that this presentation, as well as all of the presentations today in this webinar, is not intended for companies who operate at the San Francisco International Airport, also known as SFO. As citywide labor laws do not apply to the airport because the airport is not located in the city and county of San Francisco. So here we are. We are at our final session, session 7, Paid Parental Leave Ordinance and Military Leave Pay Protection Act. I'm Beverly Popek, your host. Our presenters for this session is Bianca Polovina and Maura Prendeville. Working our questions and answers box, we also have Maura Prendeville doing double duty. And as I said, if you don't get an answer by the end of this webinar, we will contact you at the email address you use to register for this webinar. And lastly, we have Sally Chin in our chat box. Good afternoon, Bianca.
Good afternoon, Beverly. And welcome everybody to the final session of the day. I am a compliance officer here at the Office of Labor Standards Enforcement, and I'm going to take you through the Paid Parental Leave Ordinance now. First of all, we should talk about what the Paid Parental Leave Ordinance is, and it's a wage replacement program. It requires covered employers to pay supplemental compensation to covered employees who are receiving California paid family leave benefits for the purpose of bonding with their new children. The whole point of this law is to help covered employees take all 8 weeks of California paid family leave without worrying about the loss of income. As I'm sure most of you know, we have no national or federal paid family leave program, and the United States is dreadfully behind and at the bottom of the world rankings for this, but California is the leader. That's why we have the paid family leave program, in part for parents to bond with their new birth, adoptive, and or foster children. And San Francisco is also a leader. This law, the Paid Parental Leave Ordinance, has been in effect since 2017, and it's the first of its kind for any municipality. So as we go through this presentation today, just keep in mind that this is all about wage replacement so that people can bond with their new children. The first thing that we should talk about when we get into the specifics of this law is whether or not this law applies to you. And we're going to talk at length about who is a covered employer. You've got to have a global count of 20 or more employees. Please note, we said a global count. You are counting everybody who is an employee anywhere in the world for you. If your number of employees fluctuates, then we're going to instruct you to take an average over the PPLO look-back period. The look-back period is going to be discussed in great detail in a little bit. Please note this law really only defines private employers as covered employers. Government entities are never going to be covered employers under this law. Not the state of California, not the federal government, not UC San Francisco, the city and county of San Francisco, school districts, city college. This is just about private employers. Assuming that you have determined you are a covered employer, you need to know what your obligations are. And the three main ones are to post and distribute the PPLO poster conspicuously in all of your work sites. 2, to provide the PPLO form to any San Francisco employee expecting to become a parent. And 3, to calculate and pay supplemental compensation on time and in full. Please keep in mind all of these resources, the PPLO poster, the PPLO form, and a special high-tech calculator our analyst team made just for you are all available on our website, www.sf.gov/PPLO. We also want to talk about who is a covered employee so that you know which employees this law might apply to. These are very important things that are to your benefit, whether they are for this law or some of our other laws, to really understand. They have to work in the geographic boundaries of San Francisco. It's very important that you understand the airport is not within the geographic boundaries of San Francisco, and you're going to need to know where your employees are working. They've got to have commenced work for you, the covered employer, at least 180 days before their leave period. And then these next 2 bullet points are about basically how we define under the law what is regular work in the geographic boundaries of San Francisco. For those part-time employees, the standard or the threshold is 8 hours per week working in the geographic boundaries of San Francisco. For full-time employees, that threshold is going to be at least 40% of their weekly hours worked in the geographic boundaries of San Francisco. Also, these employees have to apply for and receive California Paid Family Leave benefits from the Employment Development Department, or the EDD. That's the state of California. We really, truly want to emphasize this final point. That is why it is in boldface here on the slide. This is just to figure out the employee's eligibility for supplemental compensation or wage replacement. The employee does not have to be covered by other state or federal laws like the California Family Rights Act or the FMLA to receive the San Francisco PPLO benefit. As the covered employer, you're going to need to analyze and assess each law separately. So, as promised, we're going to spend a little bit of time talking about the PPLO look-back period. It's really important to know what this is, especially when you call our office to reach out for help. I would say 85 to 90% of the time that you call and there's some kind of interesting facts about you, the employer, or your employees, we're going to ask you about the look-back period, okay? So simply put, what we're essentially looking at is this block of time before the first day that the employee goes on paid family leave. Depending on your pay schedule, that's either going to be 3 monthly pay periods, 6 semi-monthly or bi-weekly pay periods, or 12 weekly pay periods. We use the look-back period in a couple different situations. One, to determine if the employee is covered when their work location changes. This is for folks who travel in and out of San Francisco. Maybe they do delivery driver work, or maybe they work at multiple locations for your business throughout the larger Bay Area, or maybe there's some other unique thing about how they work. You need to know where they are working. So you will have to reference that if the work location fluctuates. This is also very useful too to determine if you as the employer are covered when your number of employees is fluctuating right around that 20 employee threshold. 3, the look-back period is also used to determine if an employee is covered when their hours fluctuate. If they are sometimes working 8 hours a week, sometimes 15, sometimes 5, that's when you've got to run the math and take an average over the look-back period to figure out, does this law apply to this worker? And then finally, even if you have a covered employer and a covered employee, sometimes wages fluctuate as well. So we will instruct you to follow the law and to calculate the average normal weekly wage whenever those wages fluctuate. So just keep in mind, if you are confused, if you don't know if you are covered as an employer, if your employee is covered as an employee, or what the normal weekly wage is, you can reach out to our office. We have compiled everything very nicely for you in this to-do list. This is basically also available on our website, styled as the step-by-step guide. And what you need to do to make sure you're in compliance with this law are 4 things. 1, post the notice. We have them on our website in multiple languages. You can download it or ask us to mail it to you, and then post it everywhere you post everything else for your employees. 2, you, and when I say you, I mean not only you on this webinar, but everybody you work with that interacts with the employees, like their direct supervisors and managers, you need to provide the PPLO form available on our website to any San Francisco employee who indicates they will be or have become a parent. 3, you need to determine employee eligibility under this law. And then 4, you need to calculate and pay the employees supplemental compensation. It's a two-way street. So we've got a to-do list or step-by-step guide for the employees as well. These 2 documents are available on our website, not just in English, but also in Spanish and Chinese. So the employees to-do list is 1, they've got to apply for California paid family leave. 2, they've got to complete the San Francisco paid parental leave form that you're going to give them. 3, they need to take the completed San Francisco paid parental leave form and the notice of computation. That's something they get after they apply for EDD benefits. And they need to, we always tell them, you got to give your employer everything. All in one go, your PPLO form and your notice of computation. And then 4, the employee also has to maintain records and receipts from the EDD. So with that, we're going to talk a little bit about paid family leave, since we've been mentioning it over and over again. We just want to make sure you all have this base point of knowledge. Paid family leave is a program that is essentially an employee-funded benefit. You can look at your own paychecks to see your contributions to this program. I'm sure out of the over 370 people who are on this call right now, at least some of the people on this call have taken paid family leave. This is a state-provided benefit of 8 weeks of partial wage replacement to employees while either 1, caring for a seriously ill family member, which we're not talking about today, or number 2, what we are talking about today, bonding with a newborn, adopted, or foster child. Depending on the income of the employee, the benefit is currently 60 to 70% of their gross normal weekly wages, up to a cap. Please note, in 2025, the PFL share will increase. We are still waiting on final guidance from the state about what this looks like. What you need to know for now is that this is going to result in employers either paying the same or less in PPLO supplemental compensation, because the PFL share is going to increase. So stay tuned for more details. It is not increasing to 100%, so you're still going to have to do all of the stuff that we're talking about in this webinar today. Please note that both parents may take paid family leave at the same time or different from each other. Paid family leave can be taken consecutively or intermittently. It is all up to the employee how they want to bond with their new child. The only real time constraint that they have is they must fully take all 8 weeks within 1 year of the birth, adoption, or foster placement. As awesome as the San Francisco Office of Labor Standards Enforcement is, we can't actually answer questions about paid family leave. We will route you over to our colleagues at the state of California. You can call the EDD as employers at 855-342-3645. So the moment I'm sure you have all been waiting for is figuring out how to actually run these numbers, how to do the calculations. So you're going to need a couple of different things. You're going to need, one, the paid parental leave form filled out by the employee and provided to them, hopefully by you. Hopefully they did not have to call our office saying, I don't know how to get started with supplemental compensation. But they will have definitely filled this out at this point. And then you also need their EDD weekly rate. That's in their notice of computation. It is always easiest if the employee can provide this to the employer and not have to wait for the EDD to send it to you. So we always tell the workers who call in, please just give this notice of computation form. You're also going to need the gross weekly wage. You should be able to get this from your pay records. You can also cross-reference it on the PPLO form from the employee. But all of these things are certainly within your control as long as you have a good system of providing the PPLO form to the employees and making sure they have enough information to complete that form and apply for their notice of computation benefit. If the employee does their job and the employer has everything it needs, you should have everything that you need in order to run these numbers. We have talked a little bit about a weekly cap. In 2024, the weekly cap on these benefits is $2,700 per week. We will find out probably within the next couple months what the 2025 cap will be, and we will clearly post this on our website. So once you have all of these documents, you can actually do the fun part and you can do some math. So what you need to figure out is this first variable, PPLO supplemental compensation. If you have the EDD paid family leave benefit and you know what the gross weekly wage is, it is pretty straightforward. Let's say your employee generally makes about $1,000 per week and you have this documentation from the EDD that says the weekly benefit amount is $700 per week. All you have to do is subtract 700 from 1,000 to get an amount of $300 per week. That's going to be your obligation as the employer. You must pay $300 per week to the employee in supplemental compensation. If they take all 8 weeks in one go of the paid family leave, that's going to be 300 times 8 equals $2,400 total. That said, now that you know how to do the calculations, you need to know when to pay the supplemental compensation. In the best case scenario, you and the employee have been in excellent communication and you've got everything you need pretty relatively soon after, or maybe even right as paid family leave is beginning. What this law says is once you've got everything you need to make your very best good faith effort to pay the supplemental compensation in accordance with your regular payroll schedule. So if you normally pay every 2 weeks, the same would be true here because you are paying this person's supplemental compensation. The law doesn't prohibit you from prepaying if that's what you want to do all in one go, if that's easier for your accounting or payroll needs. What you need to be very focused about and avoid at all costs is the absolute deadline. If the employee has already come back to work from paid family leave and you haven't paid them any supplemental compensation, this should set off several alarms within accounting, payroll, HR, benefits, wherever it needs to, because you, as the employer, are liable for penalties if the employee has not received all of their supplemental compensation within 30 days after the paid family leave period has ended and they're back to work. This is something you definitely don't want happening to you. Some of the largest investigations that we have had in this office have been started by exactly those types of cases. So you're at this webinar to learn and to make sure that you are developing best practices. So what we want to share with you is some common compliance issues. These are errors that other employers have made. We want to make sure you don't make these errors. So the number one issue that we always see is a failure to notify. You as the employer can solve so many issues before they even happen if you will simply just notify employees about their rights as soon as you become aware that the employee is going to become a parent. You should not only give them the PPLO form, but also document when and how you provided it. It is the best case scenario when you're able to do it in a structured way like this. There are so many times when my coworkers and I have been trying to do outreach or even investigative work that if the employer had just done this, we would not be taking all this time and effort to make things right. So notifying employees about their rights will save you a lot of time and stress later on. We also want to break down some common misconceptions that are possibly already even happening in this chat box. So we just want to make it very clear. Look at the names of these laws. This is about paid family leave and paid parental leave. This is for all parents. It's not just for birth mothers. It is for everybody. The employee can take this leave again. They can take it all in one go, but they can take it intermittently as well. They can take 2 weeks at a time here, 4 weeks there, and their final 2 weeks at a later time. It is all up to that employee how they structure their leave. Another strange but unfortunately common misconception that we frequently run into is, oh, I don't need to notify the employees of the law if they haven't been here that long. This is not true. This is baseless. Please do not do this. It's pretty preposterous. So just keep in mind that you should institute the best practice of notifying people about their rights, giving them that paid parental leave form as soon as you find out that they are going to become a parent. So with that, we do want to suggest some best practices that will help you as you get things going. One, your employee handbook or employee portal, whatever you call it, should have adequate information about the PPLO. It should have the PPLO poster on it. It should have information like a link to our website and so many other things. That will save you a lot of time and stress. Two, you should train everybody. It's not just up to HR or benefits teams. You need to also make sure that managers and supervisors are trained as well. The ones that are going to hear, in many cases, directly from the employee that they're becoming a parent, it's not always going to be HR. Sometimes it's going to be direct supervisors. So those of you who have teams that you're reporting back to should be making follow-up appointments to make sure folks are trained. You also, third, should keep records of the PPLO form, the language it was provided in, when it was provided to the employee, and when the employee gave it back to you. This will help you with so many different potential inquiries from both the employee and our office. We also recommend that you communicate with the employee before, during, and after leave. If the employee starts calling us, the Office of Labor Standards Enforcement, saying, I can't get a hold of my employer, is that a good look for you? You don't want that. You should also maintain all your EDD records and payroll records in case there are any disputes, questions, or concerns. You should also use the calculation instructions and the calculator that our amazing analyst team put together for all of you. We made these tools so that you could use them, and we want you to use them. So please do visit our website and make sure you have these things downloaded. You should also pay the employees their supplemental compensation at their regularly scheduled pay periods. And finally, you should always feel free to contact the Office of Labor Standards Enforcement whenever you might have questions. So just to recap some of the resources that are on our website, we've got everything. We've got the notice, we have webinar slides and audio presentations, we've got that awesome Excel calculator with the written calculation instructions, we have FAQs, we have the text of the law itself, plus the rules that our office issued to interpret and enforce it. And we have a number of employer and employee documents, all in multiple languages. So please do visit and bookmark sf.gov/pplo. We are going to take questions at the end in a live way. If you have other things that come up, this is how to get a hold of us. This is our email address, pplo@sfgov.org, and our phone number, 415-554-4190. We can help you with anything about the paid parental leave ordinance. Unfortunately, we're not going to be able to help you with anything that pertains to paid family leave, state disability, pregnancy disability leave, the FMLA, the California Family Rights Act, tax advice. We're not the state or the federal government. We will do our best to answer what is in our wheelhouse. And with that, I will hand things over to, I believe, the next presenter to take us through before we get to a global question and answer. Hi, Maura.
Hi, Bianca. Thank you for that informative presentation. Let me click onto the next slide. Okay, I'm going to be covering the Military Leave Pay Protection Act today. Before I dive into this, I want to make sure that you understand that this law only applies to companies or entities that have 100 or more employees. So quite a few of the laws we discussed today have a threshold of 20. This one has a threshold of 100. So if you're not at that size and don't expect to be at that size, you can opt out of this section of the webinar. Like the other laws we discussed, the location of the company's headquarters is not relevant. So it's about where the work is being performed. And government entities are not covered by this law. So city employees like ourselves, state employees, other governmental employees are not covered by this law. And again, the caveat about San Francisco Airport, that is not within the city of San Francisco's limits. And so airport employers are also not covered by this law. If you are at that size, what do you need to do? First, you need to notify employees about their rights under this law. Put information about this in your next employee handbook. We also have a poster for this law that should be posted at the workplace. Similarly to the PPLO, when you have someone on military leave, you're going to be calculating and paying them supplemental compensation during their leave. What this law does not do is it does not provide job protection for employees who are going on military leave because they already have that through different federal and state laws. This law is relatively new, so it just became operative at the beginning of 2023. And basically the purpose of it is that, a lot of people who serve the U.S. either through being a military reservist or being in the National Guard, they often are required to take time off from their civilian jobs to be able to partake in training and other necessary responses. So we see a lot of people in this situation who are deployed to natural disaster zones in the U.S. So, hurricane rescues, protecting state and federal capitals, and of course overseas. So if you have employees that are in this situation, most of the time they do suffer an income loss when they go out on that leave, because often the amount that they get from the military service does not compare to the amount that they make from their day jobs. So the purpose of this law was to avoid a loss of income for members of the military when they take leave from their civilian jobs. Okay, so if you're a covered employer, meaning you have 100 or more employees worldwide, which of your employees are covered by this law? It's got to be an employee who's in the Armed Forces, National Guard, or any other branch of the U.S. military, and they have to work for the employer in San Francisco. There is no, unlike most of the other laws, there's no requirement about how long they needed to have worked for you. So you could have someone who their first week on the job says, hey, I just got called out to go respond to an emergency or to go to a training. It does include part-time and temporary employees. There is no difference between full-time and part-time, or seasonal workers, or people who have certain positions or certain salary amounts. None of that matters. All they need to do is work for you in San Francisco and be a member of the Reserve or National Guard or some other organization like that. This is very similar to the PPLO. The way you calculate it is the employee will be able to show you how much they're going to be getting from the military. So depending on which branch they're in, they might have different documentation that they show you, but they can say, here's what I'm getting from the military. And you basically subtract that from what they would normally be earning. So the combination of the supplemental pay from the employer plus their military pay should get them to their normal wages. So again, it's the difference between their gross military pay and the amount of pay the employee would have received had they been working their regular schedule. We also use a look-back period. If a person has an irregular work schedule, then you would look at their average earnings over a look-back period. And you don't need to pay for employees for days that the employee would be working outside of San Francisco. So for example, say you have someone who is a nurse and they work 20 hours a week at a San Francisco hospital and then 20 hours a week at an Oakland hospital. If that person goes on leave for a month to do their military duty, you wouldn't need to supplement for the time that they would have spent in Oakland. You only would supplement the pay that they would have earned in San Francisco. And I'll repeat that a couple times because that can be confusing. How do you know how much pay the employee is getting? So it can vary based off of what branch they're in, what their rank is. The employee will often have the best sense of how they can get this documentation and show it to you. They may have written military orders that show it, or they may have a wage statement. There's also a link that's available on our website to the federal government, where you can use that to kind of anticipate what you think the pay might be if you can't find any other way to confirm that. It is okay to estimate and make adjustments in the subsequent pay periods if you are unable to confirm the amount of supplemental compensation, or excuse me, the amount of military pay that they're getting before they are deployed. And then the only thing you want to watch out for is you want to make sure the employee doesn't receive more than they would have if they hadn't gone on military leave. Similarly to the PPLO, military leave can be taken incrementally. So you may have someone who attends, for example, a 3-day training, and they only need to take 3 days, then you only need to supplement those 3 days of pay. And then the maximum here is 30 days in a calendar year. So you may have an employee that says, hey, I'm about to get deployed abroad and I'm going to be gone for 6 months. You're going to be required under other laws, state and federal laws, to protect their job. But the San Francisco law would only require that you supplement their pay for up to 30 days. So anybody with a long deployment, you're your obligation as an employer is capped at 30 days in a calendar year. So the timing, you want to make a good faith effort to provide supplemental compensation according to the regular payroll cycle whenever their leave began. Other requirements, you just basically record keeping like you would for any other law. You want to have records of the military leave pay that you got from the employees. You want to keep records of the pay that you provided in the form of supplemental compensation. And if there's any issue about how much they should have received, you want to make sure you keep copies of their schedules and their hours worked in case the employee comes back with questions about how you calculated the amount. We've got some information here on our website. You can also download the poster there, and we've got some FAQs. And like all the other laws, we have a hotline available to employers if you have questions.
Well, thank you, Maura. We are at our questions and answers session, and there were some questions that came in. Maura, I'm going to give you a little bit of a break because you're doing double duty, and there are some questions in which I have here for Bianca for PPLO. But folks, if you haven't already, go ahead and put in your questions in the questions and answers box. And if we do not select your questions or your question was not answered today, do not worry. We will contact you at the email address you provided at the time of registration for this webinar. With that said, Bianca, the first question we have here is this for PDL and SDI too? And maybe you should tell us what PDL and SDI means in terms of these acronyms.
Sure thing, Beverly. That's a good question. So there's a lot of different kinds of leaves that are available to people and a lot of different wage replacement programs that the state of California has. And so SDI, state disability, or PDL, pregnancy disability leave, this is sort of what happens when a birth mother is not able to work because of pregnancy or sometimes complications of pregnancy even after childbirth. So just keep in mind that the PPLO is about bonding with the new child. So sometimes for some birth mothers, you as the employer are maybe going to need to get a little information from either the EDD or the employee to know, okay, when is this part of the disability ending and when does paid family leave begin? And it's when paid family leave begins that you as the employer need to start paying the supplemental compensation. So that just kind of ties back to one of our earlier best tips for compliance is remaining in appropriate contact with the employee before, during, and after they become a parent so that you might know if they have exited the disability leave part of being away and off from work because of becoming a new parent and then entering into the paid family leave period. PPLO supplemental compensation needs only to be paid during paid family leave.
Thanks for that. This question is about whether or not this company has to comply with the PPLO. The employer writes, we have an internal paid family leave benefit in our company. Do we still have to comply with the PPLO?
That's a good question. It depends without knowing anything more specific. So what we always tell every employer is no matter what, whether or not you have an internal program that you offer some kind of paid leave for new parents, you need to have the OLSC PPLO poster available, posted physically or on intranet. When this other thing happens, which the law kind of calls integration of an existing benefit, you might not need to pay additional supplemental compensation, but it really depends on the specific facts and circumstances around your internal company policy. And we actually have a whole huge section of the law that's devoted to exactly this. Pretty much if your internal company policy does at least as much as this law requires, if not more, you're probably going to be okay, but you still need to be able to communicate this very clearly to your employees. So just keep in mind, our law says 8 weeks of leave for all kinds of parents. So if you have something that's like 4 weeks paid, but only for birth mothers, that's kind of getting into some questionable territory. You can reach out to us with the specifics of your particular plan. In the meantime, absolutely, definitely stay posting for our poster, keep that up to date. And then if you are of the belief that you have such a rich internal policy that your employees don't need to take paid family leave with the state, you need to be able to explain to your employees how great your policy is. Please contact us with specific questions about your internal leave policy.
That's great. Thank you. This next question, the employer writes, does the PPLO apply to people who work from home?
It doesn't actually matter where they work in terms of home, office, delivery truck, and so on. What really matters is the geographic location of their work. So if they're working from their home, office, delivery truck, cafe, etc., and that place is within the geographic boundaries of San Francisco, they're on their way to being a covered employee under this law. If they're working from home outside of San Francisco or in an office outside of San Francisco, then that would not be to their benefit.
Thank you. This person writes, I think we have a PPLO compliance problem. What should we do?
You should call our office immediately. You should probably try to figure out the scope of the issue and then give us a call on our hotline. I saw this question come in and I know Maura answered it. We're generally here to pick up the phone Monday through Friday from 9 to 5. That does not include holidays, of course, but we do our best to be as responsive as possible and strive to return all of our calls same business day or next business day.
Great. This one writes, our office is in Mountain View. Do we still have to comply with the PPLO?
You will still have to comply with the PPLO as a Mountain View company if you have employees who are working regularly in the geographic boundaries of San Francisco. Unlike some of the other laws, you don't need a business location in San Francisco for this law to apply to your company.
Thanks for that one and the clarification. Calculations. Are tips included in the calculations for an average weekly wage? How are bonuses?
Great question. So we, in the city, we use the state's definition of wages. Tips do not count as wages. A lot of bonuses do count as wages. And so we've got this information that is up on our website and the FAQs, possibly the rules. If you have a wage fluctuation issue or something that's very unique about your company and your compensation structure, don't hesitate to reach out to us for more guidance.
Great. And this one says, can I just use all the employee sick time for this?
Absolutely not. So that's good we got that question. You will see when you look at the PPLO form on our website that there is some discussion of the use of potentially accrued and unused vacation leave. If you have separate leaves between vacation and sick, you cannot touch the sick leave. You can potentially use up to 2 weeks of accrued and unused vacation leave because vacation earned under state law is defined as wages. You can convert some of that toward your supplemental compensation liability. You cannot touch sick leave.
Well, thanks for that. So all of the other questions for PPLO will be answered directly to you via the email address you used to register for this webinar. And I think I'm going to move over to military leave to Maura. Thank you, Bianca. Maura, this first question, this person writes, do I have to pay supplemental compensation during weekend military training?
The answer is it depends. So if the person is not normally scheduled to work on the weekend, then no. So if you're dealing with, an office worker who works Monday through Friday and they are they're doing their reserve training on Saturday and Sunday, you don't need to supplement their pay because they wouldn't be scheduled to work during that time period. However, if it's an employee like a healthcare worker who does work weekends and they're regularly scheduled to work weekends, then you would need to supplement the pay.
And that's good to keep in mind. How far in advance does my employee have to notify me before they take military leave?
Within a reasonable amount of time, but please keep in mind that a lot of times these employees get called up with very little notice. So if it's an emergency, they may not be able to give you much notice. Something like a scheduled training, they should let you know when they become aware of the need to take time off work.
Okay, and then this last question, how should I inform my employees about this particular act?
There is a mandated poster. So there's a poster available on our website that you want to post at the workplace where you have your other labor law posters. And you want to include information about this in your employee handbook. And anytime an employee comes forward and says that they need to take military leave, then you want to make sure that they're aware of it at that point as well.
Great. Well, folks, we've had over 330 something questions today. We are unable to answer everything during this webinar, and do not worry, we will get back to you at the email address you use to register for this particular webinar. I want to thank you all for attending this webinar, and I want to thank the staff of the Office of Labor Standards Enforcement, Jade San Diego, Sally Chin, Helen Morales Velasquez, Josh Pastrish, Gabrielle Moses, Maura Prendeville, Bianca Polovina, and Angela Chu. Thank you so much all, and have a great day. Take care.